Mr. Vigneault, will you swear on a religious document or do you wish to affirm?
I will affirm.
For the record, please state your full name and spell it out.
David Vigneault, D-A-V-I-D, V-I-G-N-E-A-U-L-T.
Do you solemnly affirm that the evidence to be given by you to this commission shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Tessier, will you swear on a religious document or do you wish to affirm?
I will affirm.
For the record, please state your full name and spell it out.
It's Michelle Tessier, M-I-C-H-E-L-L-E, T-E-S-S-I-E-R.
Do you solemnly affirm that the evidence to be given by you to this commission shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Chaillet, will you swear on a religious document or do you wish to affirm?
I will affirm.
For the record, please state your full name and spell it out.
Marie-Hélène Chaillet, M-A-R-I-E-H-E-L-E-L-E-C-H-A-Y-E-R.
Affirmez-vous solennellement que le témoignage que vous allez rendre devant la commission sur la vérité, toute la vérité et rien que la vérité?
Oui.
Merci.
Good morning, and this is now our third opportunity to see each other and go through the evidence that you'll be giving to the Commission this morning. And what I'd like to do is begin with a little bit of housekeeping. I'll remind Mr. Commissioner, I'll remind parties through you that we have already had the interview summary of these three witnesses adopted during the closed session, which took place on November 5th. We also had the confidential and public versions of the institutional report adopted during that session. But the one item that has not yet been adopted is the summary that was posted yesterday of the closed session. And so witnesses, I would ask you each in turn to confirm that you reviewed that summary for accuracy and adopted as part of the evidence of CSIS and ITAC before the Commission today. Can you each confirm that?
Yes.
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 Thank you. And now to begin, for those to whom each of you is not already familiar to the public, if I could ask you, Mr. Vigneault, to begin by describing your role and function within CSIS.
Yes. So I've been appointed the director of CSIS in June 2017. In those functions, I have the full responsibility and authority over the organization, and I am supported by a group of senior executives, including Madame Tessier here with me today. And I can go into further details about the mandate of the organization now or later.
Let me, if I could, ask the clerk to call up just on that point, because you've set out your mandate in your institutional report. Mr. Clerk, could you pull up DOJ.IR 701? I'm inferring from the number of this document that CSIS was the first federal government institution to get its institutional report filed. And witnesses, if we go to the second page, Mr. Clerk, if you could scroll down just to the top, that exactly there, thank you. And we see in the second sentence there, and I'll read it and you can follow along with me, Mr. Vigneault. CSIS's core mandate is to investigate threats to the security of Canada and advise the government of Canada on such threats. See that there?
Yep.
And you confirm that is the core mandate of CSIS?
Yes, it is.
Okay, thank you. Now, Ms. Tessier, you are the Deputy Director of Operations at CSIS, correct?
That's correct.
And can you describe your role in that position?
Certainly. I'm responsible for the overall management of service operational activities and the governance of those activities.
The way we've found it convenient to describe it to those who aren't familiar with the bureaucracy of the service is to describe you as the most senior intelligence officer in the service. Is that a fair description?
That's correct.
Thank you. Ms. Chaillet, you're with ITAC. Could you tell us what your role is there, and in general terms what ITAC is? We'll go into a little more detail later, but just for introductory purposes.
Yes, certainly. I am the executive director of ITAC. I've been in that position since September 2021. ITAC is an organization that was created in 2004 out of the National Security Policy to independently produce threat assessment using a broad range of intelligence and information, both at the unclassified and classified level. We have three main lines of operations. The first one is to assess and recommend the national terrorism threat level for Canada. The second one is to report and assess terrorism-related event trends and threats. And the last one is to assess and set terrorism threat level for a Canadian interest worldwide.
Thank you. And can you describe in general terms the relationship between ITAC and CSIS?
Yes, so ITAC is co-located with CSIS headquarters, and we operate under the CSIS Act. And so I do have a reporting relationship to the director of the service. And my organization works very closely with CSIS partners. We have access to the intelligence that is collected by the service, and we assess it independently.
Thank you. You used a phrase there, and I'll just take you to the words that are used in your materials, which is that ITAC operates under the authorities of the CSIS Act. Now, we don't see ITAC mentioned in the CSIS Act. Am I correct there?
That's correct.
So can you explain for the Commissioner why you would characterize ITAC as operating under the authorities of the CSIS Act?
Yes, of course. So as I mentioned, ITAC was created in 2004, so after the CSIS Act was enacted. And when it was created, after the 9/11 incident, basically, to avoid silos in intelligence assessment. And when it was created, it was decided by the government of the time to put it under the CSIS Act. So all the founding documents, the founding documentation of the center stipulates that it operates under the CSIS Act.
So the institution put itself under the authority of the CSIS Act, even though it's not mentioned there?
The government of the day decided to put it under the CSIS Act.
Nice move. When you say ITAC is responsible for determining the national terrorism threat level, can you explain how those determinations are made?
Yes, actually, ITAC is responsible to recommend the national terrorism threat level. The director of the service sets the level.
Thank you. Well, why don't you describe exactly that, the input you have, and then the role that the director plays in that?
Yes. So we use a very rigorous methodology to do that. So our analysts are trained to look at a number of indicators to come up with a recommendation. So the methodology uses both qualitative indicators and quantitative indicators. We look at all available intelligence. We consult with many security partners, and we specifically do an assessment of threat actors' intent, capabilities, and opportunities to conduct an act of terrorism. It's very important to point out that the assessment is specifically on the likelihood of an act of terrorism occurring in Canada. So once we've done all this work, those consultations, this analysis, we do it at least 3 times a year, or more often is required. When I'm satisfied with the assessment, we present it to the director, who then decides whether or not he takes the recommendation on the proposed level.
And just before we go over to you, Mr. Vigneault, as to your role in this, perhaps, Madam Chaillet, you could explain whether there is any relationship between the definition we've seen a lot of in this hearing, that is the 2 sub C definition of threat to the security of Canada, and the conclusion you and your organization reached on the national terrorism threat level.
Yes, of course. So so as you very well know, the 2C and all the Act unlocks investigative powers for the service, right? ITAC is not a collecting agency. We do not collect intelligence. We assess already collected intelligence. And so the intelligence that the service collects under 2C, this is the intelligence that we assess along with other informations or consultations with partners to come up with the recommendation at threat level.
If I understand what you're saying, the recommendation that you make as to a threat level isn't a recommendation that a 2C threat has been found.
No.
These are independent concepts.
Yes.
Okay, thank you. Now over to you, Mr. Vigneault. When you received the recommendation from ITAC, what's your role?
So, of course, after reviewing carefully the material, I need to satisfy myself that I concur with the analysis. And I can, agree or disagree with the recommendation to set the threat level. And so I do that, as Madame Chaillet described, regularly during the year, or as required if there is a specific incident that, happens in between those set time periods.
And tell me, is this sometimes a subject of dialogue between CSIS and ITAC, where you receive a threat level recommendation and perhaps ask for more information or query the conclusion or give other feedback? Mm-hmm.
The way it works is that it could be a combination of, regular dialogue. And so while the assessment is being made, Madame Chaillet and I will have part of different meetings. We'll discuss terrorism issues in Canada and abroad. And so our common understanding will be formed through those discussions. And it happens also that, when I receive the formal material, I will ask to sit down with the executive director of ITAC to formally question some elements to make sure that I understand exactly what's the basis of the analysis and make sure that I'm comfortable with such analysis. And then I'm the position to make the determination of the threat level.
Thank you. Now, witnesses, we are going to go through an exercise that we Commission Council have colloquially called CSIS 101, similar to some of the questions you got asked in your interview and in the closed session. Probably, Madame Tessier, these are mostly for you. This is your working, the concepts you work with every day, but other witnesses, please feel free to add or qualify as you think appropriate. And these questions, witnesses, will be about your core mandate, so what soon we will come to call your Section 12 mandate, but your mandate to investigate threats to the security of Canada. And so let's start with Section 12. And Mr. Clerk, if you could call, you might already have it on hand. It's the same document, the DOJ.IR.701. And page 2, you have in the second paragraph that begins pursuant, an extract from Section 12. Which I'll just read for the transcript. Pursuant, the first part is a lead-in, and I'll mention when the quotation starts. Pursuant to Section 12 of the CSIS Act, CSIS, and here the extract from the Act begins, shall collect, by investigation or otherwise, to the extent that it is strictly necessary, and analyze and retain information and intelligence respecting activities that may on reasonable grounds be suspected of constituting threats to the security of Canada, and in relation thereto shall report to and advise the Government of Canada. Now, perhaps I'll put it over to you, Ms. Tessier, to describe the function that Section 12 serves in the CSIS, in the core mandate work of CSIS.
Certainly. Thank you for the question. It is really what defines what our mandate is, as you mentioned, in terms of opening investigation, collecting information, and reporting to the Government of Canada. The intelligence cycle is such that the Government of Canada issues intelligence requirements to the security and intelligence community, of which CSIS, of course, is a part. And we then issue direction to our regional offices to collect the information that can fulfill that intelligence requirement. We analyze it in our headquarters, and we subsequently disseminate our assessments to the Government of Canada.
Right. And we'll probably come back to this as we're discussing some of the other definitions, but is it fair to say that if we go to the second line there and the words information and intelligence respecting activities, that activities is a central concept in Section 12 and in your mandate?
Absolutely. And of course, it's related to Section 2 of the Act, which
Right.
describes the threats.
Yes, Section 2 particularizes the types of activities that could form threats, but in particular, you're not investigating ideas, you're investigating activities, right? You're investigating when perhaps ideas motivate people to action.
That's correct.
Okay. And the standard, which we've already seen talked about a fair bit in the hearing to date, is in the third line there, that is to conduct an investigation, to have the authority to investigate these activities. The grounds of proof are described there as activities that may on reasonable grounds be suspected of constituting threats. So sometimes shortened to reasonable grounds to suspect. And that's the basic threshold that decides when, if I'm going to put it in my terms, when you go from being a sponge, just absorbing information and monitoring situations to actively collecting and investigating a target. Is that a fair description?
Yes, it is the threshold that we must meet before initiating an investigation.
Thank you. Mr. Clerk, could we go over to page 6 of this same document? And at about 3/4 of the way down that page, there's the heading Targeting Authority. And the first sentence describes a standard for your operations. It's the second paragraph that I want to focus on for a minute here. And this is, if you were to ask the question, activities of whom or activities of what is it that you're investigating? And so you would use the expression, if I can ask you to confirm this to make sure I've got it correct, Ms. Tessier, the activities of an individual, a group of persons, or an organization. Is that correct?
That's correct.
And to follow through with the definition we've just worked with, whose activities are reasonably suspected of constituting a threat. And then this is expanded in the second sentence of this same paragraph, which I'll read. CSIS may also target issues or events to allow for an investigation of activities which are reasonably suspected of constituting a threat to the security of Canada that arise because of or are related to the issue or event. And then parenthetically, you give the example of threats to Vancouver 2010 Olympics. And perhaps you could, the example, threats to Vancouver 2010 Olympics, is helpful. Perhaps you could help us flesh out the concept of targeting issues or events with another example of an issue or event that might have come under the service's attention for the purposes of an investigation of a threat.
Certainly, that type of targeting level is normally used when there's what we call a special event, where you can have high-profile individuals attend, such as politicians or the like, who could be victims of a variety of threats. So it allows us, when we don't have a specific, I'll call it an aligned threat, to be able to investigate leads that may come out as a result of that event being held and any potential threat to that event, to spectators, to the individuals attending, high-profile personalities, that type of issue.
And do you have an example of when an issue might be something that is constituting a threat?
It's not, to be clear, it's not the actual event or issue that is the threat. It's the ability to investigate activities that, because that event is being held, there could be a threat that comes as a result of that. So it's not the issue or event itself.
Thank you. I got lazy there in my description. What you're talking about is an issue or an event in relation to which there could be activities that themselves constitute the threat, correct?
That's correct.
And so if I can take you back to the question, is there an example that comes to mind of where an issue might give rise to activities that constitute a threat?
As I mentioned, several high-profile issues where there's a gathering of personalities such as a G7, G20 event, the Olympic Games, significant events that could attract threat actors to target that event.
In this context, could an issue be an ideology like Islamic terrorism?
That would be, if that falls within the activities of a threat to terrorism does, of course, under 2C, right, then that would be its own. It wouldn't necessarily be a more general issue-based event that would fall squarely under 2C of the CSIS Act.
Okay. And so we've got, if I follow this correctly, looking at these, at the listings in paragraph 2, we could have an individual, a group of persons, or an organization who any of those could be involved in activities, or the target could be issues or events that allow for an investigation of activities that are suspected of constituting a threat because of or related to the issue or event. So it can be a permutation of those 3 categories of targets on their own or in conjunction with an issue or event. Correct?
That's correct.
Now, let's get to that more refined level of description of the threat activities, and a good place to find that, Mr. Clerk, if you can go back to page 2, we'll see in the footnote to page 2 the extract of Section 2 of the CSIS Act. And just, Ms. Tessier, to help put this in context, Section 2 of the CSIS Act is the section that contains a long list of definitions, one of which is threats to the security of Canada, correct?
That's correct.
I say that because sometimes we talk almost exclusively about Section 2 as if threats is all it is. But when we say 2C, we actually mean the threat, the definition of threat to the security of Canada that is the third of the subcategories of threats to the security of Canada, correct?
That's correct.
And is it fair to say that for the purposes we are talking about in relation to the convoy, the blockades, the protests that in January and February of this year, that certainly the concentration and ultimately, I think the exclusive area of interest for potential threats or for investigation of threats would be 2C. Is that right?
That's right.
Okay. And I'll just read that out again so it appears in the transcript. Activities within or relating to Canada directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective within Canada or a foreign state. And so that we don't have to keep repeating that, in your community, you often refer to threat-related activities as a compact way of describing 2C?
We often refer to it as terrorism, but yeah, threat-related activities.
Okay.
related to terrorism.
Other phrases I've seen are threats of serious violence, and we all built into that, we know it has to be all of those other words, including ideologically motivated, et cetera. But if you hear me use that expression, threats of serious violence or activities directed towards serious violence, you'll know that I'm talking about a 2C threat. Can we agree on that?
I would be careful on that because there could be criminal activity that is serious violence, a murder, a homicide, that is not related to the security of Canada. So I would just want to be clear that it has to relate to, as you pointed out, the various components of 2C.
So you might want me to always add the words for the purpose of achieving a political, religious, or ideological objective at the end. I think
if you refer to the CSIS Act and 2C of the CSIS Act, I think will be.
2C will know what you mean. Okay.
Yes.
Now, assuming you meet your reasonable grounds to suspect threshold under Section 12, then depending on the urgency and seriousness of the threat and the resources you have available, you could decide to open an investigation. And then you have to decide what investigative tools you're going to use to pursue that investigation, correct?
That's correct.
And where I'm going to take you here is that there are certain investigative tools you can use having only that reasonable grounds to suspect as the standard of certainty you have. That is, generally speaking, we'll call them the less intrusive investigative tools, correct?
Correct.
Surveillance, collecting information from open sources, basically building a file, but not going so far into the level of intrusiveness that you would actually need a warrant, correct?
If it's only reasonable grounds to suspect, that's correct.
Right. And then if the circumstances, which might be the seriousness of the threat or the difficulty you have in collecting information on it, so indicated appropriate, you might then apply to a court to get more intrusive, to get authorities, judicially granted authorities for more intrusive investigative techniques, right?
Yes, once we go past the threshold of reasonable grounds to believe, at that point, yes, we can apply for a federal court warrant.
Right. I'm going to try to break that up into smaller pieces and suggest that what you realize is that you need more investigative authorities than you have without a warrant, and then you see if you have reasonable grounds to believe that there is a threat to the security of Canada, because you know you are going to have to satisfy a judge on that point before you will get the warrant, right?
That's correct, yeah.
Okay. And the reason I want to break it out there is I think you'll agree if we can make this observation that the higher evidentiary threshold of reasonable grounds to believe there's a threat to the security of Canada, that standard of certainty has to do with the fact that you are using more intrusive techniques. You always had the authority to investigate once you passed the reasonable grounds to suspect threshold, correct?
Yes.
So the higher threshold of reasonable grounds to believe isn't what gives you the authority to investigate, it's what gives you authority to use more intrusive investigative techniques.
Yes, that's correct.
Thank you. And in terms of resources, another factor that I would expect to play into this analysis you do is that you've only got so many intelligence officers, you've got a lot of information coming in, so there's some proportionality and triaging, et cetera, that you do when you decide which threats that do plausibly meet the reasonable grounds to suspect threshold you're actually going to devote your resources to, and how much resources you'll devote to them.
Yes, and of course it's often dictated, well, it's always dictated by the nature of the threat, the gravity, because we can go very quickly into reasonable grounds to believe, of course, depending on the nature of the information we receive at that time.
Okay, now on that point, I'd like to make or ask you to make an observation that we've seen in your interview summary and It's come out in the materials that the parties have already seen. And it has to do with the allocation of its counterterrorism resources that the service has devoted to, and here we're going to introduce the acronym. I think almost everybody knows what it means now, but IMVE, ideologically motivated violent extremism. And so can you tell the Commissioner, relatively speaking, of all of the resources of the service that are devoted to counterterrorism operations, what proportion of those resources are devoted to dealing with the IMVE threat?
Approximately 50%.
Okay. And how does that relate, say, to the proportion that, and I'm just going to ask you to make a rough approximation here, that would have applied 10 years ago, say?
It's a significant increase, maybe not from 10 years ago, but from certainly, yes. I think when we look at events that have occurred in Canada, with, as an example, Alexandre Bissonnette, Quebec City Mosque shooting, Alex Manassian, and the unfortunate event in Toronto where he ran over a number of individuals. When we see an increase in those types of activities, we obviously proportionately place our resource to investigate what we see as a very significant and growing threat.
Okay, so even with and to the extent there are still threats out there from organized terrorist groups like Al-Qaeda or other groups that took so many of your resources back around the turn of the century, you are now devoting either half or more than half of your resources exclusively to responding to the IMVE threat. Is that correct?
That's correct.
Thank you. Now, at that point, I'm going to ask Ms. Khan to come up and expand some more on that threat and the way that the service has handled it, and then I'll come back afterwards with some questions that follow on that.
Good morning. It's good to see you again. Good morning, Mr. Commissioner. For the record, I'm Nasser Khan, Commission Counsel. I think my questions are probably best placed to you, Ms. Tessier, but as Mr. Cameron said, please, if the other panelists feel able, jump in where you feel it's appropriate. So I would like to go through the IMVE framework that the service has adopted with you. And I understand that this terminology and this framework is something that the service has adopted as a policy framework in recent years. Is that correct?
That's correct.
Okay, so I'm going to pull up a placemat, which I think you're no doubt familiar with. It's COM 50946. And while that's coming up, perhaps you've touched on this already a bit, Ms. Tessier, but perhaps you can explain what led to the adoption of this terminology and this framework.
Thank you. I will say at the outset that ideologically motivated violent extremism is very difficult to define when it meets a CSIS threshold, when it meets the threshold of terrorism. And that is something that we share internationally when we're talking with our partners because it is a complex threat. We adopted that term because of the complexity and the number of ideologies that can fit into it. We didn't want to get into right-wing, left-wing. That can mean different things to different people. It could be just a legitimate viewpoint. And so we wanted to highlight the various, I'll call them steps or criteria is a better word, that would bring CSIS's investigations into the fore. So we want it to be ideologically motivated. So that it's not just a personal grievance. It is something somebody fundamentally believes in. And they want a societal change. So they want to change the world. They really believe in this extreme vision of changing society. And then, of course, serious violence, death. They are looking to kill.
Right. And so I understand you're referring to the 4 criteria that are set out in this placemat there. So we see willingness to kill, attempting to affect societal change, ideological influence, and serious violence. So these are the criteria that would that would lead the service to determine that there is a threat under 2C in particular. Is that right?
That's right. It's not an exact science. And I think it's important to realize that given the nature of this type of threat, we do try to develop this criteria. And as a matter of fact, many of our international allies have adopted the same vocabulary because we know it's challenging. So we try to narrow it to those criteria in order for CSIS to begin its investigations.
Okay, so perhaps we can walk through the criteria in turn. So I'll just note, actually, before we go there, a threat actor in this scenario is not somebody that the target that the service is investigating. Is that correct?
Sorry, I don't think I understand your question.
So in order for somebody to move from being an actor into a target,
right,
they would have to meet these three criteria. Is
yes,
that correct?
That's correct. Yes.
And an actor doesn't necessarily need to be a person or an individual. Is that correct?
Well, normally it could be a group, could be an organization.
And could that include cells or platforms or networks more broadly? I'm
not sure. Cells, of course, are composed of individuals. I mean, ultimately, you're dealing with individuals. Even if it's a group or an organization, they're composed of individuals.
Okay. So perhaps let's go to the first criteria, willingness to kill or inspire others to kill. So what would be sufficient to meet that criteria?
Our information indicating that somebody is seriously has communicated that they want to commit murder, that they're acquiring arms, but it could also mean damaging property in such a way that could lead to somebody being killed, even if that wasn't the initial intent. It could also be inciting individuals to violence, because oftentimes it is the consumers of that type of propaganda who could be the ones who become radicalized and commit the act.
Right. So I want to pick up on something you just said there. You said it could be destruction to property as well if it leads to loss of life. Is that a fair characterization?
Yes.
So there has to be the potential for loss of life.
Yes.
So if we zoom in to this placemat onto scenario 3 there, this is a scenario in which presumably there's a threat to one of Canada's 10 critical infrastructure sectors. And loss of life isn't an objective per se, but it's a possible outcome, and that's what would trigger this criteria.
Yes, that's correct.
So if we just scroll to the next page, please, Mr. Clerk. So I think there's a definition up there about serious violence. And if we just zoom in a little bit more and scroll to the right, serious violence in relation to the 10 Government of Canada critical infrastructure sectors is defined as a threat actor who willfully destroys or damages property if such actions could endanger a person's life. And that's what we were just referring to, correct?
That's correct.
So, for example, a willingness to engage in just pure destruction of property, if all the other criteria are met, wouldn't be sufficient to bring somebody up to the level of being a target. Is that correct?
Yeah, not necessary, but yes.
Okay, and so would an example of this be somebody, for instance, who might want to tear down a statue for an ideological purpose and for a desire to affect societal change, but because the potential of loss of life isn't made out, they wouldn't rise to the level of being a threat. Is that correct?
That's a fair statement, yes.
Okay. And how might an actor demonstrate a willingness to kill or to inspire others to kill? So you mentioned inciting violence. Would that be posting things online?
It could include posting things online. Sometimes it's more covert than that, but it could, yes.
Okay, and would passive engagement or consumption of that content indicate a willingness to kill?
I'm not sure I understand what you mean by passive engagement.
Perhaps somebody who's engaging with violent content online.
Right.
Just looking at it, reading it, browsing it, would that be sufficient to meet this criteria?
No, not all.
Okay. So we'll turn to the next criteria, which is the desire to attempt societal change. If we can just zoom out, Mr. Clerk. And just go back up to the top page, please. So can you expand on what might meet this criteria, attempting to affect societal change?
Absolutely. When we look at the IMV movement, because that's what it is, it's composition of movements, many members believe in what they call accelerationism, which is a belief that society needs to change. If we take white supremacists as an example, or anti-immigration individuals who believe that their society is at risk either of immigration, of government intervention, of anything they see, they feel that society is at risk and that there's going to be a civil war. So they believe they must take violent action to speed up that societal change and to put society back as to, in their vision, is the way it should be. So that's an example of societal change where they really adhere to this accelerationist mindset, if you will.
Okay. And so would somebody who's protesting meet the criteria for attempting to affect societal change?
Not necessarily. I would just want to highlight that CSIS cannot, by its law, investigate lawful protest or dissent, unless it's related to one of the threats to the security of Canada.
Right. And so protest alone wouldn't be sufficient to meet this criteria?
No, it would not.
Okay. And so turning to the third criteria there, ideological influence, you've touched on this already in using the word movements. So I see in the top left corner of that placemat, if we zoom in just in the bubble that says ideologically motivated, I see there are 4, I think, broad movements that the service has identified as falling under this category. Can you speak to them, please?
Certainly. There's xenophobic violence, as I mentioned earlier, anti-authority violence, so anti-government, gender-driven violence, and what we call other grievance. That could be like extreme environmental groups or animal rights type anti-abortion. I mean, the extreme violent movements, it's meant to capture that type of ideology.
So why does the service use the lens of movements and not discrete groups?
If we look at terrorism as we're traditionally used to looking at it, we've very much been focused on groups. And those groups, I'll use Al-Qaeda as an example, very much a command and control structure where you had to be vetted and you had to really be accepted as a member of the group and very tightly held, and you had to go to training camps and the like to be considered a member of Al-Qaeda. While there are groups in the IMVE space, they're not as defined in the same way. They don't necessarily have command and control. And it's really a movement of individuals of sometimes various elements of these ideologies and networks of individuals is a better way of describing it than actual strict groups, as what we've seen in the past.
Right. And so these are broad categories, broad networks, and participation in any one of them, of course, isn't alone on its own because you've got the other criteria there.
Yes, that's right. And we've seen, I've given a couple of examples, but we've seen cases where individuals, they don't belong to any group, but they adhere or they're influenced by these movements and they decide to act and commit terrorist attacks.
So can you just explain to the Commission what the anti-public health measures movement is?
Anti-public health came out, of course, as a result of the pandemic, and individuals who felt that government was overreaching by their health regulations in terms of wearing a mask or the vaccinations or what have you.
And that would fall under which of these categories?
Well, it's not an issue or a movement that the service investigated. However, we have seen some of our subjects of investigation in the IMVE space exploit that type of a movement. If they're anti-authority, if that's the ideology that they subscribe to, and they see government intervention, then they can exploit that to justify their ideology and say, yet again, government is overreaching. That type of an example. In and of itself, anti-public health is not of concern to CSIS.
Right. And so what would be that anchor that brings it into the purview of the service?
Again, it would be more the individuals who exploit that type of a movement to recruit individuals, to bring them more towards the extreme view of anti-authority ideology, wanting to use violence, serious violence, to kill, to bring changes.
Right. And so that reference to serious violence is effectively what brings you back to 2C.
Yes.
Correct. Okay. Yes. And you mentioned another word there, Ms. Tessier, accelerationism. Can you expand on what that is?
As I mentioned, and I'm not the security expert on this, but as I mentioned, it is a view that they have to accelerate the change of society because they're not satisfied with how society is right now. As I mentioned, they could be xenophobic, they could be anti-authority, and they feel the only way to make a change is not using the democratic process and voting, but rather to use serious violence to kill, to bring about that change, because it's not happening in the current state of affairs.
Right. And so I understand from your institutional report and from your witness summaries that the service has seen a rise in anti-public health measures content online. Is that fair?
I'd say what we've seen a rise of is anti-authority rhetoric, violent rhetoric, and threats against public officials. With certainly there was a rise when the public health measures were put into place, but when those were loosened, then of course the rhetoric towards that particular issue went down. But what has increased is threats against public officials, politicians.
And has that posed a challenge at all for the service?
It's certainly of concern to the service.
Yes. So how does the service go about distinguishing between credible threats of violence and something that might just be a social media post that expresses anti-authority views? We take
various measures. First of all, the service doesn't monitor all social media. I don't think we'd want our intelligence services to be monitoring everybody's social media. So it's very focused where we believe there are threats being communicated, if you will, or that are related to our mandate. And but we use all our methodologies. If we feel that we have sufficient information to begin investigation, then we'll use the techniques and our methodologies, such as surveillance or what have you, that enable us to investigate that threat further. But it is always a challenge to know when somebody's going to move from the online space to the physical space. That's obviously of great concern. And as I mentioned earlier, it's often not necessarily the person posting the rhetoric, but the person consuming it who can decide to become radicalized and then act.
Right. So, please.
No, I was just also just to reinforce something that Ms. Tessier mentioned. So it's not always the people making the threat that we're most concerned about. It's the people who will consume that rhetoric and be triggered and mobilized to violence. And to also answer another of your questions to how we evaluate the threats. At ITAC, we look at this fairly closely. And we apply the same type of methodology that we use for the terrorism threat level, which is to look at the threat actors, their intent, their capability, and their opportunities. And so our analysts are trained, they have very detailed tradecraft to learn to evaluate the intent based on a message. A message that says, I wish that person would get killed, is really not the same as a message that says, I really dislike this person. I just acquired a gun and I'm going to shoot the person. So I'm exaggerating, but it's just to give you the idea of how we actually look at those threats and look at them very closely with that tradecraft and that methodology in mind.
Right, and this tradecraft that ITAC applies would be, or the methodology is distinct from these 3 or 4 criteria that the service is applying. Is that correct?
No, not entirely, because when we fall under the CSIS Act, so we look at the potential for terrorism, and so in that case, we don't look at just any serious violence, and so it needs to be motivated by our ideology. It needs to be done in the purpose of leading to a societal change. So in that sense, it's not completely different. It's just that we use it differently. We don't use it to determine whether or not we can collect on people, since we don't collect intelligence.
Okay, thank you. So I'm going to ask you to define two big concepts, and so I'll pose this question to the whole panel. One thing that the service is struggling with, as I understand, is dealing with misinformation and disinformation as it navigates the challenges of determining between assessing credible threats online and online rhetoric. So can you explain to the Commission what misinformation and disinformation might mean and how that impacts your work in determining threats under Section 2C?
Certainly, I can answer that. My colleagues can certainly add any comments they like. Misinformation tends to be erroneous information that continues to be sent online, communicated online, not necessarily knowing that the information is erroneous. Disinformation is purposely spreading false information, if that helps at all.
I think that's for the purpose here. I think it's the best definition, unless you want to elaborate more, but I totally agree with what was said here.
So where would engaging with misinformation or disinformation fall on these criteria? Sorry, can we just zoom out a little bit more, Mr. Clerk?
Maybe I will essentially on this one. I think it's not just a question of misinformation, disinformation, because that is in and of itself not something that, we need to be aware of it, conscious of it, but it's not something that we need to determine ourselves. It's more linking back to the intent and the capabilities of the individual. So unfortunately, social media, internet is full of information that is misleading, that could be misinformation, as Ms. Stacey described, could be also purposefully misleading, so that would be disinformation. So I think, we're more interested in understanding that dynamic and then apply that understanding to our analysis of specific activities, specific individuals. So I think that would be more a better description of how we, the service, would be conscious and aware and apply those principles.
Right, so you're aware of the fact that there are things circulating online that might not be violent rhetoric or that might not reflect a desire to engage in violence, but you've got to keep a general awareness of that. Is that fair to say? Yeah,
because what we have seen, unfortunately, a number of the individuals that who have perpetrated act of terrorism in Canada, we've had, since 2014, we have 25 people who have been killed in terrorist activities, by people who were motivated by violent extremist ideologies. And so when you dissect, deconstruct their motivation, often because they left manifestos or writings behind and so on, you see a conflation of different issues. It could be xenophobic ideology. And then when you start to look at the material and the understanding, you realize that there is a lot of misinformation and disinformation that is weaved into their writings or their understanding that creates that belief for these individuals that they must act. So that's why we, CSIS, will need to have that kind of awareness, not because we will be interested, in every misinformation, disinformation that exists, but that reality informs the threat-related activity of that we must investigate.
Thank you. I'd like to shift gears now, so we can just take that document down, Mr. Clerk. Thank you, and talk to you about the services activities in respect of the convoy in particular. So, as I understand it, the service was aware or had pre-existing targets and came to learn of the convoy through that activity. Is that fair?
Sorry, we became aware of the convoy. Yes, of course.
Right, and so the service had pre-existing targets who might have been involved.
Yes, we had pre-existing targets in the IMVE space, to be clear.
And was the service at any point?
Please.
Sorry, was the service at any point investigating the protest itself?
So maybe if I can step back a little bit, just to make sure that we provide the Commission with the best possible overview. We, of course, have been, generally aware of, what's happening in our country. We have seen the tension that, was created by reticence or a different perspective on public health measures. We saw, of course, in the mid-January when the government mandate on that will apply to truckers, was being discussed and was about to take effect. We saw this kind of, increasing volatility and intensity of being opposing those measures. So we kept a general awareness of that. We saw some subject of investigation of CSIS, so the individuals were already meeting the thresholds that Ms. Tessier described earlier. Start to get interested in the discussion and discussing potential ways of engaging. And so at that point, we started to engage more resources, both in our headquarters in terms of analytical understanding, but also across the region. CSIS is an intelligence organization that has offices across the country and across the world. So we started to engage our regional offices in Canada and some stations abroad to better understand the dynamic. And so we that evolution, of our or the intensity of our work, followed the events of January and February.
Right, but the service was not investigating the anti-public health measures movement broadly, for example, and it certainly wasn't investigating the convoy itself as a discrete topic.
No.
Is that right?
As was mentioned earlier, we are prevented by law to investigate protest and lawful dissent. We're not investigating the convoy itself. Our interest is to understand how that dynamic is potentially influencing individuals that were known already to CSIS, and others potentially to radicalize further and engage in potential threat-related activity. So we were not investigating the convoy.
Right, and so the service's focus remained at all times on its targets and their participation or their involvement, as it may be, in those protests.
I would maybe clarify, Commissioner. I would say that we were, of course, focusing on our subject of investigations, but also the dynamic of such events is that you have people. Sometimes it can refer to lone wolves or individuals who might be further radicalized by the protest, and so our work was to engage with our federal partners, with law enforcement at the federal, provincial, municipal level, in Ottawa and across the country to understand how potentially what was happening in the protest world, if I can put it this way, could have an influence on individuals those who were known already to us are subject to investigations, or others who could be radicalized. So it was essentially a twofold analysis, making sure we understood what our subject investigations were doing, associating with, and so on, but also understanding who were others who could potentially radicalize, who could potentially start to recruit and meet others to further threat-related activity. And so that focus is one that we maintain from the beginning to the end, and to a large extent that's what we continue to do, is we always make sure that we don't have tunnel vision in our analysis, is that we challenge ourselves on an ongoing basis to make sure that our perspective of threat-related activity is not just linear and doesn't change. We were on an ongoing basis, because of that exchange of information with other organizations, challenging ourselves to make sure, do we really understand well the dynamic here, and how does this apply to the CSIS Act, and how our intelligence professionals are executing?
Right. So would it be fair to say CSIS was looking at the protests in conjunction with its targets, as the Section 2C definition allows?
Our targets, but also looking at the broader perspective to see if others would eventually engage in such activity that they could become subject of investigations. So
looking for potential threats.
Yes.
Okay. I would like to pull up a document, TSNSC CAN 50165. So I'll take you through a few briefs that the service prepared in the course of the protests, and we can discuss them. So do you recognize this document, Mr. Vigneault?
Yes.
Can you explain to us what it is?
As per the title, these are notes that were prepared for a senior executive in the organization, Ms. Tessier or myself, to brief outside partners. In this case would be Minister Mendicino, Minister of Public Safety, who I report to as Director of CSIS.
So this would have been a ministerial briefing that you would have provided, is that right?
Yeah, well, I think we can describe it like that.
Right. And so this is January 27th, around the time of the first ADM NSOPS meeting, is that fair?
Yeah, I trust that those dates are accurate, yeah.
Okay. So I just want to go through the content. If we can scroll down a bit, we have sort of the very first assessment prepared by the service, I think, of the Freedom Convoy. And so there's a bullet there that says CSIS is investigating IMVE activities and monitoring IMVE social media content. There has been online commentary calling for violence and storming Parliament Hill buildings. And then the next bullet, CSIS is tracking engagement of its targets in relation to the convoy. Over the coming days, CSIS will be monitoring the involvement of these targets and other persons of interest, in particular for any indications of mobilization to violence. So what do those two bullets mean there? What does CSIS will be monitoring the involvement of these targets and other persons of interest, in particular for indications of mobilization to violence, mean?
So I think, as we were just describing in the previous exchange, is that we had already an awareness of a number of individuals in Canada who were engaged in activities that met our threshold for 2C investigations. And so we were aware that some of these individuals were interested in paying a lot of close interest to the convoy and trying to understand, what it meant, saw potential opportunities. And so we were looking at those individuals. So these are the known actors, if you want. Our work as well is to make sure, as I mentioned, that we don't have tunnel vision, that we just don't look at what we know, but also in this context of other people who might be influenced by the events, by some specific decision by the government, some specific radical rhetoric online to say, it is my time, I need to do something. So our professionals at CSIS and in ITAC are trained to really understand well the distinctions we're talking about 2C and so on, about what is lawful dissent and protest versus what are activities that could be potentially, threat-related activity under the CSIS Act. So this is a description of that at a high level of that type of work that was ongoing during that period.
So is the assessment there that there's a possibility of a lone actor threat? Is that it?
Yes, essentially at that point, late January, we're looking at such an activity because based on, again, experience of our professionals, we have seen individuals who seize opportunities to engage in those acts, either because they had previous beliefs or because they are in events or activities or what they might read, consume in terms of information is radicalizing them extremely quickly.
So a person that's not known to the service, but that could
Absolutely.
be mobilized. So at the bottom there, we see the bullet, CSIS is unaware at this time of any tangible plots or plans of serious violence. And so at this stage, there's no risk of a threat materializing.
I would not necessarily say there's no risk, as we just that we're not aware of it. And so I think, it is I think Ms. Tessier used the expression earlier, it's not an exact science. And what I think is very important to remember, as in this event and other events of the sort that we've seen in the US and other democracies, is that there could be a very quick turn of events. There could be very quick radicalization or shift in the dynamic of these. So at that point, we did not see, so the 27th, when the report was written, we were not seeing any tangible plot of violence. But that's not to say that there was no risk. And that's why we were, as I said earlier, engaging all necessary resources in Ottawa and across the country to understand what was happening.
Okay, so we'll go to the next brief, which is TS/NSC CAN 001-50166. So do you recognize this document?
Yes, I do.
And can you explain to us what it is?
Yes, this is as the title explains, an analytical brief. So it's prepared by senior analyst, intelligence analyst within CSIS to try to contextualize, provide an assessment of some information or facts that may appear, and it's to use their expert knowledge and apply analytical tradecraft to take facts and events and try to make some sense out of them so that we have an understanding within the service and ITAC of what this means. And this distribution here also means that it would have been shared more broadly across government. So it's to have CSIS, share our analysis with other members of the government about a specific event.
Who would you have been sharing this brief with?
This would have been shared actually at this level of classification. It would have been shared very broadly across government, federal government. So we're talking, most departments across the federal government and many individuals within each department.
And
specifically, that would have been for sure the analytical intelligence branches of the key government departments involved in the monitoring of the activities of the Freedom Convoy and associated demonstrations.
And would it have been shared with PCO?
Absolutely.
Okay, thank you. If we scroll down to page 3 there, I think we see the assessment here. Aside from individuals who specifically identified themselves as part of the convoy group, the service is unaware of the presence of IMVE groups at this weekend's protest. Then if we scroll down all the way, the presence of racist and bigoted flags appear to have been brought by individuals who would like others to believe that their cause or belief is far greater and more organized than it actually is. CSIS assesses that these flags were not part of a broader group initiative. So this is February 2nd, and the service is still reporting there isn't a threat under Section 2C arising from the protests itself. Is that fair to say?
I'm not sure that this is... I think the purpose of this was more to, again, use the expertise of CSIS IMV analyst to try to share with other groups, individuals, organizations that may not be as familiar as CSIS is on these issues, to say that we have seen in the past people waving flags at different demonstrations, and when you do the analysis, it's not to say that, there were a large number of people associated with those flags. It could be here, it is essentially, there was a number of commentary made in the media and other places that trying to draw an inference between if there is such a flag, that means there are lots of people associated with this cause. This was to use the best analysis possible from our intelligence experts to contextualize that information, to try to make sense for people who are not experts of what we saw and how we analyzed this event.
Right, so at this stage, we're seeing indicators or symbols at the protests that might lead one to believe that there are extremist groups involved in the protest, and the service is saying that's not necessarily the case.
it's not to say that it's not the case, but it's to be more nuanced in the analysis, because this is very complex, and people who were not experts, may draw conclusions. And our attempt with these types of report is to say, based on our analysis, based on the information we have, based on all of the knowledge that we have, this is the context in how we are interpreting this. It doesn't mean that CSIS is right, but I think it's very important for us to share that analysis with others.
Okay. So I'll take you to the last brief, and that's TSNSC CAN 00150-211, please. Okay, so if we can just zoom out a bit so that we can see the entire page, please. So I believe this brief is dated February 10th. Are you familiar with this document?
Yes. I don't see the date on it, though.
I think it's just at the bottom of the page there.
Okay.
So this is a brief, again, on the protests. If we just look at the title, it says Anti-Public Health Measures Movement, Grievances, and the Freedom Convoy 2022. So if we scroll to the bottom of page 2, we have the outlook prepared by the service. Sorry, if we scroll up a bit as well. So we see there, just before the redaction, no formal organized plot of violence has been identified. CSIS assesses that the Freedom Convoy 2022 is of interest to various subjects of investigation, especially those who hold anti-mandate or broader anti-government views. And then just underneath outlook there, CSIS will continue to monitor the involvement of IMVEs within the Freedom Convoy 2022 in order to better understand the public health measures movement. So what is the assessment being shared here?
So essentially, as the first line above the outlook you mentioned is that at that point, CSIS assessment was that we did not see specific actions being taken that would characterize a threat to the security of Canada associated with the events. Okay.
And so the last question that I'll pose to you before I turn it back over to Mr. Cameron is, the Commission has heard evidence about the distinction between lawful and unlawful protests. So in this period between January 27th up to February 10th, you might have even formed the view, just as a personal opinion, that the protests might have gone from being a lawful one to an unlawful one. Would that have had any bearing on your assessments or on your work?
No, because it's not the criteria we'll be looking at per se. It has, again, related to violence. So we're going back very closely to the 2C definition we've talked about earlier. So a declaration of an event that is unlawful. For example, you can have a permit for a demonstration, and then, there's too many people, therefore your demonstration is outside the bounds of the permit. It could be unlawful, but that would not engage us. So the unlawfulness in and of itself alone is not just a criteria that would be determinative for CSIS.
Can I add something? And it's the last line on page 2 here. If I can read it. Further, CSIS will also continue to follow the evolving and dynamic situation surrounding the convoy to identify any national security concerns. That is really important to underline, is that this was a very fluid, volatile environment, and we were constantly doing our assessments. Every day we were re-looking at our information, our investigations, to ensure that we were up to our assessments. So I just want to underline that it's sometimes it's a snapshot in time, that date when that particular brief was written, but that we were also very aware that this was very much a fluid situation.
Okay, thank you.
Now, witnesses, what I'm going to do is pick up now with following on that helpful information you were able to give us about the IMVE space and how it fit in with your observations of the convoy and protest and blockade activities. I just want to run through, and this will all sound familiar, and indeed to the parties who've had a chance to read the summary of the closed session, this will be similar to a series of questions that you answered there, leading up to some context that I want to bring to the questions that follow. So what I'm going to do is just ask you about your involvement in the government and other in the government, in the law enforcement, and other intelligence communities as you were all watching the protests and the blockades, et cetera, evolve. So first of all, as the materials indicate, I think you'll agree that CSIS attended, had a representative attending and participating in the ADM NS Ops meetings, and I think we know that acronym now, so I won't bother spelling it out. Can you confirm that?
Yes.
Yes. And CSIS, a representative, attended the DMOC meetings in relation to the convoy and blockade events?
Yes.
And you had regular interaction with the NSIA about the convoy and blockade events?
Yes.
And you were a member, when it was formed, of the combined intelligence group that was set up so that all the intelligence collected by the various law enforcement and intelligence agencies could be shared among the parties involved in the convoy and blockade events?
Yes.
And CSIS was a member, or at least had a representative at Intersect meetings, that broader group of law enforcement and first responder personnel involved in major events such as the convoy posed for Ottawa.
Yes.
And indeed, if we step back to before the actual formation of the combined intelligence group, it looks from the documentation that CSIS was receiving intelligence such as the Hendon reports that were generated by the OPP and other information that once they became involved, the OPS was also generating with respect to intelligence on the convoy?
Yes.
Okay. And if we could call up again, Mr. Clerk, please, the information, the institutional report, all 701, and go to page 13. At about halfway down. Now, here's I think exactly where we were picking up, Ms. Tessier, with your comment about the dynamic nature of the events that were unfolding in front of you, and putting it in context of what I was just describing about your many-faceted interrelations with the intelligence and law enforcement community. It says here, CSIS continually monitored streams of intelligence and shared information with domestic and foreign partners, including through the One Vision processes with the RCMP and police of jurisdiction, to assess threats of serious violence in relation to the convoy. And here I'm going to ask you to remember and see if you can provide for me in this open forum that your classified institutional report contained an actual itemization of all of the agencies. And I don't need you to be more specific than you want to be, but it was tens or dozens of agencies that you were collecting and sharing information with, correct?
Yes, that's correct. We have, as was mentioned earlier, we have offices throughout Canada, and we deal with police of jurisdiction at all levels.
Right. So to the extent that there was intelligence or information available in relation to potential threats to the security of Canada as defined in the CSIS Act, it was received and considered by the service.
Yes, that's accurate.
Thank you. Now, if we can look at where you were giving input. We looked at where you were getting and sharing intelligence stuff, where you were giving input to government. If we go to page 13 again, just a little bit higher, or I guess immediately above where we just were, cabinet meetings. You and, was that Mr. Vigneault, you were attending mostly to the SSE and the IRG meetings?
Most of them, Ms. Stacey attended a couple as well.
Thank you. Where your role was, and I am quoting here at the end of the paragraph, to provide updates on national security threats that may arise and answer questions. So that was your role at those cabinet meetings, correct?
Yes.
Yeah. Now, if we can go to, Mr. Clerk, the witness summary, which is the interview summary, which is WTS 60. So 6 zeros and then 60. And thank you. If you can go to page 5, about 2/3 of the way down. And this is just to situate you. This is a paragraph from the summary of the interview we had when we were meeting with you earlier in the year. And it reads in the first paragraph under the heading intelligence, Mr. Vigneault stated that at no point did the service assess that the protests in Ottawa or elsewhere, and then there's a parenthetical definition of what that refers to, constituted a threat to the security of Canada as defined by Section 2 of the CSIS Act, and that CSIS cannot investigate activity constituting lawful protest. And I'm going to ask you to hold these thoughts in your mind, but I'll just, on that point, you recollect telling us that during the interview, Mr. Vigneault?
Yes, I do.
Yes. And if we go to page 8 of the same document, about halfway down, under the heading recommendation to cabinet, the first line there is Mr. Vigneault learned that the EA, which would be the Emergencies Act, referenced the threat definition set out in Section 2 of the CSIS Act once the federal government began to seriously consider invoking the Emergencies Act. And then there's the parenthetical date bracket there between the 10th and 13th of February. And then you've requested that the service prepare a threat assessment on the risks associated with the invocation of the Act. And then the last sentence is the one I was going to link to the earlier one you made, which is he felt an obligation to clearly convey the service's position that there did not exist a threat to the security of Canada as defined by the service's legal mandate. And again, you recollect us telling us that during the interview?
Yes.
And your legal mandate, as we saw it, I don't think we need to call it up because you can probably recite it from heart and thus recognize it when I put it to you. That legal mandate that you're describing when you say as defined by the service's legal mandate is to investigate threats to the security of Canada and advise the government of Canada on such threats, correct?
Yes.
If we can go now to, Mr. Clerk, WTS 6079, this is the public summary of the closed session we had on November 5th. And the bottom of page 5 of that and I'll read there, Mr. Vigneault explained that the advice and the assessments they would be giving to government is taken in conjunction by the decision maker with all of the other different pieces of analysis for the decision. And Mr. Clerk, if you can scroll down to follow with me. Different pieces of analysis for the decision maker to make a determination in the end if this is a threat to national security or not. When CSIS looks at national security, in this case, their assessment was that this was not a threat to national security within the confines of the CSIS Act. And you remember saying that, Mr. Vigneault?
Yes.
And then sticking with you, Mr. Vigneault, for one more, over at the top of page 6, sorry, the bottom of page 6, over to the top of 7, Mr. Vigneault confirmed a statement from the Commission's interview with CSIS, and you might recognize this as the one we started out with, and the interview with CSIS and ITAC, to the effect that at no point did the service assess that the protests in Ottawa or elsewhere, defined as the Freedom Convoy, constituted a threat to the security of Canada under Section 2 of the CSIS Act, and that CSIS cannot investigate activity constituting lawful protest unless conducted in conjunction with a threat-related activity. And then you conclude that paragraph, Mr. Vigneault confirmed that to the extent that he was able to give input on this topic at Cabinet and IRG meetings, this was the view he expressed. And again, do you recall making those statements?
Yes.
Now over to you, Ms. Tessier. At the top of page 10 of the open summary, the public summary of the closed session, we have your description, and I'll read it out. Ms. Tessier explained that the service's determination that the convoy and related protests did not constitute a threat to the security of Canada was not made by a singular analyst or executive. Rather, strategic analysts provided multiple assessments throughout the relevant period, which were approved at higher levels before they were disseminated. Mr. Vigneault explained that the assessment process is not a binary one, but an ongoing, dynamic consideration of whether the information collected was rising to the level of a threat to national security. So I think, Ms. Tessier, you can agree with both the first and second part of that statement. That is, you can agree with Mr. Vigneault, because that's your point about the dynamic nature of the assessment, correct?
That's correct.
And Mr. Vigneault, you remember adding that to Ms. Tessier's thought there?
Yes.
Okay. Now, I'd like to take you to page 8 of the open summary. Sorry, the public summary of the closed session. And moving to the bottom of that page, the advice to cabinet heading, and here we, in the open, sorry, Mr. Clerk, I've confused you. Just for a second, if I could ask you to go up to the very top, just so we can situate ourselves. Here we've started in the closed ex parte session, the examination by Counsel for the Government of Canada. So if you can scroll back down to the bottom again. And here, Mr. Vigneault, I will read the paragraph that the preceding paragraphs are leading up to. The preceding ones I've cited to you. Mr. Vigneault stated that at the end of the February 13th IRG meeting, following the discussion of the Emergencies Act, he was asked by the Prime Minister to provide an opinion as to whether he supported the invocation of the Emergency Act. Mr. Vigneault explained that based on both his understanding that the Emergencies Act definition of threat to the security of Canada was broader than the CSIS Act, as well as based on his opinion of everything he had seen to that point, he advised the Prime Minister of his belief that it was indeed required to invoke the Act. And again, you remember saying that during the closed session?
Yes.
Okay. And if I can just break that out a bit, if I understand what you're saying there, you have an understanding we might find out later in the week where you got that understanding, but I'll let you keep that as a mystery for now. You had an understanding that the Emergencies Act definition of threat to the security of Canada was broader than the CSIS Act definition, correct?
Yes, and maybe if you allow me, Commissioner, just want to go back to the first element that you took me through, Mr. Cameron, which was that when I learned that the Emergencies Act was to be invoked, I informed myself. So this is, I think, is the crux of the issue. So as director of CSIS, we are very familiar. My colleague and I, we know the Act fairly well, of CSIS Act. I was not familiar with the details of the Emergencies Act. So when that was first brought up, the fact that the Emergencies Act was using the same words as the CSIS Act to define the threat, so imported into the Emergencies Act, I needed to understand for myself and for the course of this, what was the implication of that, and that's when I was assured that there was a separate understanding. The confines of the CSIS Act, the same words based on legal interpretation, jurisprudence, federal court rulings, and so on. There was a very clear understanding of what those words meant in the confines of the CSIS Act. And what I was reassured by is that there was, in the context of the Emergencies Act, there was to be a separate interpretation based on the confines of that act. And that it was, instrumental starting on the 10th, I believe, when we discussed that, to make sure that we understand, and how we would be not informing, but using the words very carefully and very much specified. When we were providing advice and information, it was based on the CSIS Act definition. So I just wanted to maybe contextualize this a little bit. So thanks for that.
Thank you for that elaboration. Now, if we can go back to that sentence at the bottom of page 8, I understand, I think that the words do speak for themselves, but I want to make sure I understand your sense of them, that based on your understanding that the Emergencies Act definition of threat to the security of Canada was broader than the CSIS Act, and then it says, as well as based on his opinion of everything he had seen to that point. So if I'm understanding the way you've put those two together, that if you take a broader definition and then look more broadly, you come up with the advice you gave to the Prime Minister of your belief that it was required to invoke the Act.
Yes, that's exactly it.
Thank you. Now, I want to sort of insert a parenthesis or come back to an observation. Mr. Clerk, can you call up SSM NSP CAN 50216. These are IRG meeting minutes for the February 13th meeting. And at page 12, we'll find the report to government that you commissioned, Mr. Vigneault, when you learned that the government was considering the invocation of the Act. And you've mentioned elsewhere in your evidence, I think it's now well understood by the Commission and the parties, that as you learned that the government was considering the invocation of the Emergencies Act, a concern that you had because of your understanding of the IMVE space, and feel free to join in, Ms. Tessier, if you want to add here, the concern was that the invocation of the Act actually had the potential to, I think the word inflame is used, but to raise the temperature and actually increase the risk of a threat of serious violence. Is that right?
Yes, it is. And this is really when, we feel that it is our responsibility, a little bit like when Ms. Khan walked me through through another of the assessment in relation to the flags. It is, we have experts, we have people inside the organizations that, really well understand those dynamics. And in this context was to make sure that the government, yes, within the confine of the reflection on the invocation of the Emergencies Act, but also more broadly about what is happening in the country and what could be, how could the dynamic change. We felt it was important that we took that expertise within the service and we shared that more broadly with partners, with the government, to so that everybody had that understanding that we had at the service. So it is within that spirit, so both in the context of the Emergencies Act, but also in the context of what we see, what could potentially see in Canada.
Right. So if I understand the purpose of this report, it was to alert the government to a potential movement in the threat environment. And by that, I'll tell you what I'm trying to get at. You weren't, by offering this assessment or deciding to do the assessment, concluding that the government itself was, by invoking the Act, engaging in activities that posed a threat to the security of Canada.
No, absolutely not. It was really much, again, based on the expertise and understanding of the IMV milieu, is to see how some of these elements can be interpreted. And Ms. Conyer asked us earlier about disinformation, misinformation, and that would be a good example of how some objective decision could be misconstrued deliberately or not, and what is the impact on potential threat activity in Canada. So that really was the spirit in which we produced that document.
Right, and this document, perhaps also in the spirit of things we see in your annual reports or some of your reports to Parliament, CSIS sometimes prepares reports to government related to threats to the security of Canada that aren't actually premised on the commencement of an investigation based on reasonable grounds that the activity poses a threat, but it's simply advice to the government, a report to the government on threat-related issues, correct?
Yes, it essentially is to use the expertise, the knowledge, and to try to bring a level of understanding or bring a light into very complex dynamic issues that are, in the case of IMV, fast evolving in our country. So we try to bring that level of understanding, yes.
Okay, and if we can go back then, Mr. Clerk, to the public summary, that's WTS 6079, and just wrap up the chronology and indeed this examination by going to page 7 of that summary. We're now at the stage where the Act has been invoked, and the point I understand you to be making in the paragraph that begins, Mr. Vigneault explained, the point being that after revocation, you continued to provide input both to partner agencies and to Cabinet through the IRG about the evolution of the protests, the blockades, etc., the convoy. So you're continuing to give input proactively, but you weren't actually asked the question, should we revoke the Act?
No, we were not.
Thank you. And with that, Mr. Commissioner, I will conclude a few minutes early.
Okay. Well, that's great. A little shorter is appreciated. So I think we'll take the morning break and come back in 15 minutes to start with the various cross-examinations.
The commission is in recess for 15 minutes. La commission est levée pour 15 minutes. The commission is reconvened. La commission reprend.
Sir, before
Okay. Oh, okay. Miss Convoy Organizers. Okay. Go ahead.
Before I begin, I'd just like to ask leave to use a certain document. I believe your council has been advised of this. I've put together an examination aid for the purpose to save time. The documents in the examination aid I will be tendering into evidence. However, not the examination aid itself. The purpose of the examination aid is so that I don't have to wait to go through each and every document one by one by one and waste the 15 minutes I have. I've compiled the records into a Word and PDF document that I'm referring to with the footnotes of each and every one that have been assigned the numbers in the database system. And I would like leave to be able to refer to that document while I'm doing my examination, sir.
Okay, and it's just a compilation of documents without comments and?
No. Yes, sir.
No comments, and the full document is there? It's not an extract?
For the most part, I had to, because I am somewhat inept when it comes to using Microsoft Word. I had to take screenshots of a couple in order to actually put them in, but they are in full.
So it's the full document. So it's
Yes.
basically a compilation of a series of documents without comment.
Correct.
Okay.
Sure. Robert McKinnon, Government of Canada. My friend is looking to put in, it looks like, parts of an affidavit attachments or affidavit itself as part of this. If it's just a document that has an ID number already on it, if that's it, that's fine. So as long as it's not just an excerpt of an affidavit that's been filed in this proceeding or the motion itself, not argument, and it's just the document. As long as there's no commentary.
No, it just, there is a couple of things summarizing the facts. If we want, I can delete every single one of them.
We have no objection to a document that's been filed in relativity, but as Commission knows, this is still being in play for a response to the motion. So it would be improper to have comments associated with that motion put as part of the document. As long as it's just the document itself with nothing more, that's fine.
Mm-hmm. And what we can do, sir, is that if my friend, he has the document, if there's issues as they arise, before I move to the next page of each one, I will check with my friend to make sure that he feels it's fair.
So, but, okay, and you don't, I'm a bit confused. I thought you said there were no comments, it was
There's
just
no-
documents.
It was documents, but I state the fact in the document before putting, it's not anything other than the fact. But as I said, I can delete that if the court would like. And if you give me 5 minutes before I start, I'll delete all of that and just send the documents with the date, if that works for the court or for the commission.
So, Mr. Commissioner, I'm just reviewing the document, and without avoiding any debates about what commentary is, there are statements before some of the documents that aren't necessarily reflective of the documents. For instance, this is the first time this photograph appeared. So again, not getting into what commentary is, Commission Counsel does have concern about that sort of statement being put in this format. I think Commission Counsel's view is the documents themselves, if they can be organized in a fashion where it's just reflecting what's in the document, that's fine.
I can do that, sir. If I can have simply 2 minutes, I think, I can do that and send it around to everybody, and it'll just have the date at the top.
Okay, well, I think that's preferable, and as I understand it, there's no objection if that's what's done, because, yeah, obviously, if it speeds up things, we're very much into that.
Yes.
So what I'd suggest is, why don't you stand down, and we'll go to the next cross-examiner, the OPP, and we can, assuming you've put it together, let me know, and we can reschedule you.
Good morning. My name is Chris Diana. I'm counsel to the OPP. And I have some questions that I may be asking all of you at some point for your thoughts. The area that I'd like to start with is about information flow. So Mr. Vigneault, maybe I'll start with you as the head of CSIS because you can speak to your role in advising kind of up the line. But as I understand it, and my friend is taking you through the definition of CSIS, but the mandate of CSIS is to investigate threats to the security of Canada. Is that correct? Is your mic on? Can you try again? Okay.
Yes.
Sorry, I didn't hear you, that's all. And part of your role is to share the appropriate information with senior decision makers in the federal public service, including the National Security Advisor and Minister of Public Safety. Is that correct?
That's accurate, but it's also broader than that. We also share information with many other partners, but on the federal level, that would be accurate.
Yes. And that's how it works. We know in the federal sphere, there are a number of law enforcement type relationships that will work in a similar way, and that they'll collect information and they'll share it with senior level decision makers. Is that correct?
Yes.
So such as CBSA, RCMP, and there are a number of others.
Yes.
And obviously you would agree that it's crucial that those senior level decision makers have all the information they need to make informed decisions.
Yes, I would say that that's what we endeavor to do, is to make sure that all relevant information is available to decision makers.
And so when we're thinking about information flow, when we think about things that can go wrong in that process, there are a couple of things, well, there are a number of things, but a couple of kind of main things that can go wrong in terms of what you do in advising decision makers. The first may be that CSIS may fail to identify certain information on potential national security threats. In other words, you might just miss on the intelligence side.
Yes, I believe I testified earlier to say that we, what we advise on is what we're aware of, and we endeavor to make sure that we are fulfilling our investigations to the extreme degrees, but we will never have the hubris to say that we know everything.
Right. And of course, if you don't know, you can't advise, right?
Yes.
Second, the information may be available, but it may not be properly communicated up the chain. That could happen, right?
I think this maybe taking a second to speak to that is that, there are different levels. Ms. Tessier's role, my role are somewhat different, and we have, people involved, at the operational level and at the regional level. So I think, it's clear that there is a lot of information that is accumulated, and there is a process of analysis and distillation of that information when it comes to our level.
Right. And it's a human process. So you might have some information that may come into certain offices, regional offices, and then it has to go up, and then it be reviewed and go up again from your level to senior decision maker. And whether it be by inadvertence or maybe not realizing its significance, there's always a possibility that something important may be missed, correct?
I would say it as a general statement is a possibility everywhere, not more specifically at CSIS or in intelligence, but I would say yes, it's an accurate reality when human beings are involved.
That's right. And that's for kind of all federal law enforcement type agencies, right?
I would say I would not want to speak to other law enforcement agencies, but from the CSIS point of view, I would say that's an accurate description of a theoretical issue. Yes.
And obviously, sometimes you may not be aware. When I say you, it could be CSIS, it could be another law enforcement agency, may not be aware of the potential significance of a certain fact, and it may just be missed.
I think it's, again, the same vein. I would say that's accurate, yes.
Okay, I would like to ask about Project Hendon briefly, and maybe Ms. Tessier, because you were kind of the lead on the actual intelligence side, as I understand it, the operational side. We do have evidence, of course, that CSIS did receive the Hendon reports that went to a number of recipients. That's correct?
Yes.
And of course, your interest in these reports would relate to the mandate of CSIS. You would be reviewing them with the CSIS mandate in mind. Is that fair?
Well, what we do with all information we receive is always assess it in terms of the relevance to our mandate.
Right. And presumably, other federal law enforcement agencies would be looking at those reports in relation to their own respective mandates. Fair?
I can't speak to what other agencies would have done with the report, no.
Okay. And I believe in the witness summary, it was stated that it was unknown if the information in the Hendon reports was actually used in reporting. Can you confirm whether that information was used?
Yes, I think the witness, the interview process, I think that's an accurate statement, but I think in summary of the information that was provided later on, we confirm that indeed CSIS was receiving Hendon reports. It's just that Ms. Tessier and I had never heard that nomenclature, but it was shared with, I know for a fact, with our regional people in Toronto, in our regional office in Toronto.
Right. And important information would have been communicated by those regional people up to your level, correct?
Yes.
Okay. Now, according to OPP Superintendent Pat Morris, and I don't know if you heard his evidence some time ago, but he testified that the OPP works very closely with CSIS. Is that fair?
Absolutely.
In particular, I think the Provincial Anti-Terrorism Section works closely with CSIS.
Yes, it does.
And OPP is also embedded with INSET, the Integrated National Security Enforcement Team.
Yes.
And you would agree the OPP is a valuable law enforcement partner?
Absolutely.
And that while Project Hendon and the reports were a new product, but they still provided a valuable source of information, correct?
I would imagine so. I've not seen the reports directly myself.
I also want to ask about the concept of information silos, which is always, I think, somewhat of a challenge in the intelligence field. It's an obvious proposition, of course, that different federal agencies have different mandates. We've looked at that before. One of the concerns, potentially, in the federal sphere is that one agency may not know or have access to information from another agency. Is that fair?
It's fair, but I would, for the commission's sake, I would say that collectively, individually, as organizations, we have learned a lot of lessons over the years, and to make sure that we move away from the risk of information being siloed. As was introduced in evidence today, CSIS and other organizations were part of groups like ADM and SOPS, the Combined Intelligence Group, Intersect, INSET, as you mentioned, sir. And so these are processes put in place to ensure that we reduce the risk to the maximum possible that there will be information siloed.
And so efforts have been made to get around the silo issue. And you would agree that one of the best ways to get around is to ensure a broad distribution of intelligence. Fair?
I would say that to a broad dissemination of the information to people who need to know, because when you have, and the complex context and the concept of need to know is important, but it's in a case like this, and I think, as we've seen in, and we may speak to that later, CSIS took a very open approach to share a lot of our information with the maximum people possible. So those who need to know specific details, we endeavor to share those details with them. And but the same thing with criminal investigations and national security investigations. You just need to make sure to maintain the integrity of those investigations. That you sometimes will you'll take the two concept of sharing as much information possible. While making sure that those who need to know have the same information. And that's what our experts are doing on a day-to-day basis, on an ongoing basis.
Because we don't want the third-party rule to kind of get in the way of broad information sharing, correct?
Well, in the case specifically of when we talk about intelligence, there is a concept called intelligence and evidence, which means that if you were to use information collected by CSIS, for example, on intelligence basis, share with law enforcement, there is a process of inherent complexity for law enforcement and eventually Crown prosecutors to use that information in open court. So there are a number of rules that are been put in place, having learned over time what the pitfalls were. And Ms. Stacey referred to earlier as the One Vision process, which is an elaborate process that has been put in place with between the RCMP and CSIS to make sure that we are sharing all of the information, relevant in the right way to enable law enforcement.
If I could address third-party rule.
Yes.
The service respects third-party rule, and the procedure is to request of that third party any sharing that we think would be useful. So we don't just share third-party information. We always ask for permission to do so.
Right. And so as far as Project Hendon is concerned, and you may not be aware, but it had a very broad distribution list that went to all federal law enforcement related agencies, and that works to break down silos. Fair?
I don't have personal knowledge of that, so can't speak to that.
All right. And final topic is on social media. Yeah. We've heard a lot in this inquiry about social media. Anyone can go on, fire up the Twitter machine, and you can find lots of vile content and threats and things of that nature on social media. Fair?
Yes.
And I believe it was mentioned in your witness summary that it's very difficult to assess the intent and impact of violent online rhetoric. That's fair?
That's fair.
You would agree that useful intelligence requires a lot more than simply scrolling through Twitter, right?
Yes, it's much more complex than that.
And Ms. Chair, you spoke about this in your evidence not that long ago, that it really requires a trained analyst to review what's there on social media and pass it through an appropriate intelligent lens, tradecraft, as you put it, before you can have a useful product. Is that fair?
Yes, when it falls within our mandate to look at a specific threat on social media, our analysts who are specially trained will take a look with that tradecraft in mind. Yes.
Right. And that is in fact what OPP did with Project Hendon, correct? They took information and they passed it through their lens and then produced it out to its partner agencies.
I don't recall the exact reports, so I wouldn't be able to say yes or no to that question.
Okay, my last question, Commissioner, I know I'm probably up against the clock. And the point I'm trying to make here is that analyzing social media to identify risks is something that should be done by subject matter experts or those trained to do so. Is that fair?
I would say that depending on what the purpose of looking at social media is, but if the purpose is to enlighten CSIS, for example, in our mandate, absolutely. And they are another level of complexity of who should have the authority, who should have the mandate to look more broadly at social media. I think it's something that we testified in our ex parte hearing as well as an interview summary. There are some challenges with social media analysis in Canada.
Sure, but from an intelligence perspective, you need an analyst to really give you proper intelligence.
Yes.
Thank you.
Okay, thank you. So are the convoy organizers organized, or should I move on to someone else? Okay, so there's organization yet to be done. The Ottawa Coalition, please.
Thank you, Mr. Commissioner. For the record, Paul Champ, Counsel for the Ottawa Coalition of Residents and Businesses. Thank you for coming today, panel. I just want to ask a question, I guess Ms. Tessier perhaps. There's a statement in one of the documents, and you've testified that the convoy protest at no time posed a threat to Canada's national security. But at the same time, isn't it true CSIS advised Cabinet that invoking the Emergencies Act itself could further inflame extreme anti-government rhetoric? Is that not the case?
I'm not sure which document you're referring to in the first statement that CSIS said at no time did the protest. Is there a document I could look at?
I apologize. Maybe it was Mr. Vigneault, the director. That was the advice you provided to Cabinet, was it not, sir?
Yeah, I believe that the statement I made was related to that the analysis continued to be that there was no threat to the security of Canada. That's the concept that we'll be normally using in our vernacular.
Yeah, by security of Canada, we're talking about 2C, violence associated with ideologically motivated objectives, right?
Yes, very much within the confine of the CSIS Act.
But Mr. Vigneault, if there was a concern that, and it was also your advice that invoking the Emergencies Act could further inflame that kind of rhetoric, correct?
It was our advice, our assessment, I would say more than our advice, our assessment was that given everything that we know about the dynamic nature of IMV milieu, that yes, some individuals might, seize on such a government measure to further inflame the rhetoric and potentially, push them to act violently. Yes.
So there was a concern. That's what I was kind of getting at, is that if the situation or some of the rhetoric was so volatile and extreme that invoking the Emergencies Act could lead to some kind of violent reaction, was that not a concern?
It's absolute concern, and if I may add, Mr. Champ, I would say that the fact that from early in January to throughout the period in question, we mobilized, our headquarters and our regional offices because we were concerned about the situation. Absolutely. So I think there are different aspects of how we are segmenting this information that I think it's important here. Yes.
And so here's a question from Ms. Tessier. I want to understand, there were some subjects of investigation present at the convoy protest, correct?
That's correct, yes.
So just so we're clear here, these were individuals for which CSIS had obtained targeting authority?
Yes.
And CSIS had obtained those targeting authorities prior to the protest. So there were individuals who were of concern prior to the Freedom Convoy protest.
Yes, that's correct.
And so that means that CSIS had reasonable grounds to suspect that these individuals could engage in threat-related activity.
That's correct.
Okay. And we also know that there were many violent threats against public officials in Ottawa. CSIS was aware of that?
Yes.
not only federal officials, but also municipal officials?
I don't recall who exactly, but I do know overall there were threats, and there continue to be increasing threats, as I mentioned earlier today, against elected officials.
Right. The mayor testified that there was an individual coming from New Brunswick who was arrested who had apparently firearms in his truck. We also heard evidence from a city councillor, Mathieu Fleury, who had to leave with his family from his home because people were coming to his house. Was CSIS following those kinds of threats against municipal officials?
As I mentioned earlier, we maintained, our focus was on our subjects of investigation, of course, but naturally, we worked very closely with our law enforcement partners, shared information, and continued to assess the situation as it related to our mandate. And as I described earlier in terms of how we assess the situation in order to open investigation.
But Ms. Tessier, just to be clear, like if someone's making a threat against a public government official, whether it's federal or municipal or provincial, isn't that inherently falling under 2C? If someone's threatening a public official because they want some type of different political decision or policy choice, isn't that inherently falling under 2C?
As I mentioned earlier today, we've developed criteria in order to invoke 2C under the IMVE threat, because there are criminal investigations that take place, there are public order incidents that take place that are not CSIS's mandate to investigate.
If I may add, Mr. Commissioner, I would just say that, as was described by Ms. Stacey and myself earlier, we're participating in all of these different groups, including Intersect and the Combined Intelligence Group, where we would be sharing information ourselves, our information, but also receiving information from other law enforcement. In this specific case, this is where you may have public safety issues versus, a threat to the security of Canada that, might be in the same kind of dynamic environment. And that this is where, by being at the same table and exchanging that information, we inform ourselves. The second point is that this was a very dynamic threat assessment that we're doing throughout this period. So by all means, if we had seen specific information about individuals wanting to engage in a way, often that flash will be more of a police investigation because of the specific threat that will be criminal nature, as opposed to an individual that might want to engage in a terrorist activity. These are not perfectly, black and white issues, and this is why we are working to exchange information very dynamically.
But Mr. Vigneault, let's just be clear that if someone's making a threat against a public official because they're trying to influence that public official, that inherently falls under 2C, does it not? Now, it may be that you don't view the threat as credible, but if it was a credible threat, it would inherently fall under 2C, would it not?
I think that if you, that's why we've took a lot of pain to inside the service and working with partners to better understand how the IMV phenomenon was interacting with the CSIS Act. And Ms. Khan walked us through, earlier, a description of how we go through the process of understanding this, what will be the sphere of CSIS responsibility, what will be the sphere of the law enforcement responsibility. And that's why I'm saying is that this is not black and white, it's dynamic, and this is why people talk to each other on an ongoing basis.
Sir, please, I'd like to give you normally I'd like to give witnesses full time to answer, but I only have a limited time. I'm just trying to get an answer because I believe I've asked it a few times here. If someone is threatening a public official because they want to influence that public official to take some policy choice, does that not inherently fall under 2C, yes or no?
Each case is looked on a case-by-case basis, and it would not be, a default proposition.
So if someone's threatening to kill a mayor or a premier because they want them to drop a public health measure, that does not necessarily fall under 2C. Is that your testimony, sir?
Yes, it is.
And so did
Sorry,
CSIS
Mr.
not
Commissioner,
look at...
if I can just add, I think as we've walked through, there are a number of other criteria that are necessary to be the CSIS Act. There is, the testimony that Ms. Stacey gave responding to Ms. Khan's questions about that placemat earlier, I think is how we are understanding and how we are exercising our authority. So I understand, Mr. Champ, you're looking for something specific, but we've described very well, I think, the process by which we're looking at these issues. And it's not because someone would only write online that they want to kill someone that it will automatically be a threat to the
Yes,
security
sir,
of
I understand that. And we're reading a lot of time just to get an easy answer to what I thought was an easy question. I thought your response was going to be, with all due respect, that yes, a threat to a public official to influence that public official would fall under 2C, but in most cases, we have not viewed these threats as credible or valid because, it's just online. I think in one of the CSIS documents, I saw shit posting or something like that. But if you viewed a threat to a public official as credible, would it not fall under 2C?
If we have, and we have done that in the past.
Could I get a yes or no answers, please, sir?
He already answered it. He
Okay,
said
well,
no,
fine, I'll move on. Thank you. So now, did CSIS look into any of those threats in the context of the convoy protest, any nexus to the convoy protest?
Probably since the mid-January until, and we continue to today, we continue to look at specific information in context of IMVE actions, blockades, and the Freedom Convoy. So we have done that very intensely throughout that period.
So you did look at those threats, and did any of those threats to public officials emanate from anyone with a nexus with the convoy protests?
I think it's, Mr. Commissioner, it's hard to speak, at large about in generic threats. I just provided an answer to the question about to Mr. Champ about the threat to public officials. And so if you have a specific threat, unfortunately, we've provided very detailed testimony to the Commission in camera about specific activities that CSIS performed during that period.
So is your answer to me then that you may or may not have investigated those threats to public officials with individuals, with threats emanating from individuals with a nexus to the convoy protest, but you can't tell us because of Section 38?
No, what I'm saying, Mr. Champ, is that we have, we've described how we have, how we are assessing the information that comes to us in the context of IMVE. We've walked through the 2C analysis earlier, and that is that analysis, that expertise, combined with new information that will come to the attention of CSIS in whatever form, exchange of information. That's essentially what we would be doing on an ongoing basis. So I cannot be more specific than that.
So I'm done with my time, sir, but I just want to make sure I understand, because I apologize. I've heard your answer a couple of times, and perhaps I'm missing it. Is that, yes, CSIS did look into those individuals, or you cannot tell us?
I did not say that, Mr. Champ. What I'm saying is that we have been looking at information that came to our attention through different venues, different platforms throughout the investigation, and that includes the information, the like you mentioned, but I cannot be more specific than that.
So that's yes?
No, I will stand by the answer I just provided, Mr. Champ.
Thank you.
Okay. Thank you. More complicated than you thought?
As always, sir, but almost done.
Okay, well, let's go to the Democracy Fund, JCCF.
Good afternoon. I'm Hatem Kir, Counsel for the Justice Center for Constitutional Freedoms. So to begin, Ms. Chaillet, the national terrorist threat level has been at medium since October 2014, right?
Yes, correct.
Okay, and it didn't change during the protests?
The threat level has 5 different levels, and they're fairly broad bands, and so the threat level fluctuates within the medium band, so it fluctuated during the convoy.
But it never left medium?
No.
Okay, thank you. Mr. Vigneault, the CSIS Act is the home statute of your organization, so is it fair to say that CSIS has expertise in applying the statute?
Yes, I would say that.
Okay. And so Section 12 requires that CSIS investigate wherever there are reasonable grounds to suspect there's a threat to the security of Canada as defined in Section 2, right?
Yes.
Okay. And so that just it doesn't require certainty. It doesn't require reasonable grounds to believe. It's just reasonable suspicion, right?
To initiate investigations, yes.
Yeah. Okay. And that's an assessment that CSIS does day in and day out?
Yes.
Okay. Now, as someone whose father was monitored by your organization for over 10 years until it was determined an investigation wasn't actually necessary, my personal experience is that it seems that your organization is very thorough. Is that a fair assessment that CSIS is rigorous in executing its duties?
I'm not sure the context of your the premise of your question, but I would say that we try to be thorough in what we do. Yes.
Right, because I mean, a big reason that your agency's members have to be thorough is that if CSIS incorrectly determines something is not a threat and then chooses not to investigate, that could lead to harms down the road, right?
I would say that investigating threats to the security of Canada is a very complex issue. Missing, signs, missing information, and having incorrect assessment is indeed something that we are very careful about. And as a learning organization, we try to make sure that we learn from the past and that we are trying to come with the best possible assessment on an ongoing basis.
Right. So you said something earlier, and I was just trying to write it down as you said it, but something to the effect that CSIS mobilized whatever resources it could in order to try and understand the Freedom Convoy protest. Is that right?
Something similar to that. Yeah, I would say it's accurate, yes.
Okay. So you've talked a bit about the potential for a lone wolf threat. Now, am I correct in thinking that that's not based off of particular intelligence? It's more of a conclusion from general principles about this kind of an event?
This is based on expert analysis by CSIS, by ITAC, and other organizations that to understand the dynamic environment in where violent rhetoric can push individuals to act. And unfortunately, we've seen a number of people who were not on the radar of anyone who were consuming this type of information and indeed, a committed act of terrorism or extreme violence. So we are, unfortunately, it is a very complex, dynamic environment, and we have to be careful about people who would be very quickly move from just being a recipient and consumer of information to someone who would radicalize to violence.
Okay, so you were just asked questions about the potential that people were present at the protests that CSIS was already monitoring, but basically your organization was keeping tabs on them, right? So, as we've said in our public testimony, we were aware of, we already had subject of investigations who we assessed were interested in the protest. We use different techniques to assure ourselves of their activities. And we also continue to look for other individuals that might be recruited or might be approached or might want to radicalize throughout the events in question, obviously respecting the mandate of CSIS. Okay, now, but just to go back to the general point, the idea is that this is a large gathering. It could be used as an opportunity by someone to commit, to engage in some sort of a threat. But that kind of threat is present at other big events like a G7 protest, right? Unfortunately, with the dynamic of what we see IMVE, the threat is persistent. This is why the national terrorism threat level is set at medium. That means that, today here in Canada, there are individuals with the capability and intention to engage in an act of terrorism. And so I would say, yes, those larger events, but also more broadly, it is a dynamic that exists throughout our society, irrespective of those large events as well.
And what I would add to that is, as I testified earlier today, part of the ideology in IMVE is anti-authority. So they exploit that type of feeling amongst people for their own, to try to recruit people to a more extremist ideology, their own more extreme ideology. Okay, thank you.
I was also just going to add, if I may, very quickly, that one of the challenges of studying IMV-related threats is that What mobilizes someone to violence can be very, very personal. The triggers are very personal. And so it's part of the assessment, the complexity is to try to understand what might bring someone to mobilize to violence. And that reason, that trigger, can be very different from people. It can depends on their very personal experience and different grievances. So it's very hard to say that type of event might trigger that kind of violent extremism reaction. It depends for everybody.
Okay, thank you. Mr. Clerk, if we could please pull up COM 50935, and if you can go to the 8th page in the file. There's a 3 at the bottom, though. That's how it's numbered. While that's being pulled up, we've heard a bit about how the definition for threats to the security of Canada doesn't include protest. Am I right in thinking that the basic idea here is that if there's a protest where one of the 4 factors aren't present, you don't investigate, and if there's a protest where the 4 factors are present, you would investigate, right?
I think the CSIS Act is pretty clear. If we look at the document, the paragraph under D, under 2D, does not include lawful advocacy, protest, or dissent unless carried on in conjunction with any of the activities cited above.
Right, so the fact that it's a protest isn't a barrier to an investigation if one of these things is present.
I would say, generally speaking, the service stays away from investigating protests. We recognize it's a democratic right in Canada, so we don't investigate protests. What this means is if, an example perhaps I can give, if we had information that a terrorist group was going to pretend to use an event in order to conduct a terrorist activity, well, of course, that would be of interest to CSIS. But we are very, very conscious and aware of balancing the rights of individuals in a democracy like Canada with our own mandate and our more intrusive techniques.
Okay, Mr. Vigneault, so looking, let's look at, we can look at A first. Based on the services assessment, there was no espionage or sabotage associated with the protest, correct?
That's correct.
So the 2A definition wasn't met?
No.
Okay. And there was no foreign interference?
We have, I think it's in our testimony that we have said that we investigated foreign interference in relation to the event, including foreign funding, and we do not see these activities amounting to a threat to the security of Canada.
So 2B wasn't met?
Yeah.
Thank you. And there wasn't any serious violence associated with the protests?
I would not say that.
Or a credible threat of serious violence?
That's not what we're looking at. We're looking at, how these events or individuals, might engage in activities that meet our threshold. This is where I was answering questions earlier about, distinction between what law enforcement would be doing in terms of serious violence versus what we would do as a CSIS under the confine of the CSIS Act.
Okay, I'll be more specific then. There were no activities within or relating to Canada directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective within Canada, correct?
Yes, and we've testified to that earlier. I think.
So 2C wasn't
2C was not met.
Okay, and just quickly, there was no credible threat to overthrowing our established system of government.
I can say that we have not investigated under 2D.
Okay, thank you. So not only was there no Section 2 threat present, but there wasn't even reasonable grounds to suspect a Section 2 threat was present.
Well, we are on the record to say that we already had individuals who had met the 2C threshold, that were subject of investigation, that were involved, and so we had legitimate grounds to be looking at what was happening. As we've said, based on our expertise, we have seen, unfortunately, events like that where individuals were very radicalized and mobilized to violence extremely quickly. So that's why we continue to expend those resources throughout those events to make sure that we, again, did not miss something.
If I could just have an indulgence to sort of hit the last point I've been working up to. I'll try to be very quick.
Yeah, although you could have skipped A, B, C, D, it's been testified to many times that it wasn't met, but go ahead.
Okay, thank you, Commissioner. So Sorry, that threat that you're speaking about is with respect to individuals, but the protest itself did not pose a Section 2 threat to the security of Canada.
What we've testified to is that we did not made a determination that the event itself, and I think it's part of our testimony, yes.
Okay, and yet you still advised the Prime Minister to invoke the Emergencies Act?
Yes, I did.
And you did that not because you thought that there was the protest posed a threat to the security of Canada as defined in Section 2 of the CSIS Act, but because you were reassured that threat to the security of Canada had a different meaning in the context of the Emergencies Act.
I think my testimony was in part that, but it was also based on all of the other information that I became aware of during all of the interdepartmental meetings and cabinet meetings I participated in. So I was provided, that opinion was provided, if you want, as a national security advisor, as opposed to the director of CSIS specifically.
Okay, and when you say that information that you had received, you're referring to your earlier comment that you were reassured that definition had a broader meaning under the Emergencies Act?
I was referring to that, but also more specifically to other events in Canada, events, in Ottawa that, convinced me to say that the powers under the Act would be necessary.
Okay, so just my final question.
Yeah, we better get at
the very last question. This determination then that the Emergencies Act standard is the definition is broader under the Emergencies Act than with respect to under the CSIS Act. That was not the product of you reading the Emergencies Act and developing your own assessment. That was advice that you had received.
That's correct.
Okay, thank you very much, and thank you for the indulgence, Mr. Commissioner.
Thank you. CCLA, please.
Good morning. My name is Kara Zwiebel. I am counsel for the Canadian Civil Liberties Association. I just maybe want to pick up where my friend just left off. And maybe we could pull up the summary of the public version of the summary of the hearing that took place, the in-camera hearing, which is WTS 6079, please. And I think it's page 8 that we want to go to. Thank you, Mr. Clerk. And if you can just scroll down to the bottom. So this statement, Mr. Vigneault, and I'm going to direct my questions to you, but if your colleagues have things they'd like to add, please do. This statement that your understanding that the Emergencies Act definition of threat to the security of Canada was broader than the CSIS Act. Where did you get that understanding? I know Mr. Cameron said maybe we'd hear about it later, but I'd like to hear about it now.
So I asked for legal interpretation.
Okay. You asked the Department of Justice?
I did.
Okay, thank you. Now, I just want to, if we can scroll down a little bit more. This is maybe a grammar or a language point that I just want to understand. It says, he advised the Prime Minister of his belief that it was indeed required to invoke the Act. Is that it referring to the government, that the government was required to invoke the Act, or that the Prime Minister, or?
I'm not sure.
Okay, but your view was that, based on this broader understanding of threats to the security of Canada, the Act should be invoked.
Yes.
Okay, so I just want to go through, and Mr. Cameron went through some of the timeline here. You had an interview with Commission Counsel on, I believe it was August 29th, and in that interview, you noted that you had only learned that the Emergencies Act referred to the CSIS definition of threats to the security of Canada when the government started to explore the possibility of invoking the Act. Is that right?
Yes, that's accurate.
Okay. And then Commission Counsel prepared a summary of that meeting, that interview with you and your colleagues. We've seen that, and that was produced earlier. And then you had this in-camera proceeding that took place. And I understand that again, you confirmed that it was CSIS's view that the definition of threats to security of Canada in the CSIS Act was not met during the convoy?
Yes.
Okay. And then under examination from the Government of Canada, this information that you advised the Prime Minister of your view that the Act should be invoked was disclosed for the first time. Is that right?
Yes, I believe it is, yeah.
So you said in your initial witness statement that you felt it was important to communicate at the IRG and to Cabinet that under CSIS's analysis, there wasn't a Section 2 threat.
What I wanted to be very clear, Mr. Commissioner, is that because it was very dynamic environment, very, a lot of moving parts, as we say. And I wanted people to be clear about how CSIS, we were analyzing the situation. And so people were talking about using different words in the media, everywhere. And we just wanted to bring a level of clarity. So that's why we said our assessment was very dynamic, and we continued to assess. But throughout that period, we wanted to make sure that people did not misinterpret based on everything that was being mentioned, that CSIS, we saw a threat to national security based on our act. So that was the purpose of us being very deliberate about that approach.
Okay, I guess, I mean, you understand that one of the purposes of this commission is to assess whether the act was properly invoked. Sorry, can you just answer audibly?
Yes.
Thank you. And I guess I'm wondering why you didn't think it was relevant when you met with Commission Counsel in August to note that you had in fact advised the Prime Minister that you believed the act should be invoked.
I think there probably two reasons, I would say. One is that very simply the question was not asked, and so just when you go through the dynamic process of the interview, so it was not specifically asked. But there was also at that point a lack of clarity in my head about what was still a cabinet confidence and what would be what I was able to say as a participant in cabinet meetings. So that was further clarified throughout that period, and that's why I think. Again, Mrs. Wiebel, you mentioned, the nature of this commission. As a senior official in government, we're never allowed to speak about cabinet confidences. We're never allowed, in the case of CSIS, to produce, a number of the information that has been, put in front of in public for Commissioner and for Canadians to see. Normally, that will not be public. So just needed to ascertain, what were the limits of what we're able to do. And when it was clarified with me that indeed I was able to speak to that, I did.
Okay, but when you met with Commission Counsel in August, you felt that you didn't feel that cabinet confidence prevented you from advising that you had advised cabinet and the IRG that you did not believe there was a threat within the meaning of the CSIS Act.
That had been clarified with me, yes.
Okay. Because I would put to you that those two pieces of information are really two sides of the same coin, that if one is not subject to cabinet confidentiality, the other one also would not be.
I understand that analysis, but I would say that just refer back to what I said. We never discuss cabinet confidences, and the information, the way that the information was communicated to witnesses in terms of what would be possible to disclose and not in terms of cabinet confidences just became clearer with the passage of time, between August and our ex parte interview.
Okay, thank you. I don't know if you had an opportunity to review the testimony given by Ms. Thomas, the National Security and Intelligence Advisor.
I briefly saw some of the key extract, yes. Okay.
So one of the things that Ms. Thomas said was that that the CSIS definition of threats to the security of Canada is quite narrow. Do you agree with that it's a narrow definition?
I would say that the CSIS Act was enacted in 1984, and I think that the world has evolved considerably since then, and that looking at the threat environment today is indeed requires probably a new look, modernizing a view of this. That's one thing. And the second thing is that we also, through jurisprudence, through federal court rulings, commission of inquiries, and review bodies who have access to all of our information, that understanding of the Act was very much more clarified, and so very with a lot of specificity, if you want, in many aspects. And so between experts at CSIS and the OJ Council, I think there is a very specific interpretation of the Act, which is in this specific case of the Commission different than the Emergencies Act.
Okay, so and I mean, you understand, of course, why, and I think you've alluded to this in other statements that you've made here today and in your witness statement, that there should be a high threshold before our intelligence services start surveilling or targeting Canadians. Would you agree with that?
Yes, I do agree.
Okay. The holding or expressing of unpopular political views should not be enough to engage CSIS's mandate.
Absolutely not. And I would say that there is an expression that we use, which is awful but lawful. And that means that some of the opinions expressed verbally or online, are not by default, even if they can be extremely violent, are not by default something that would allow or necessitate CSIS to investigate.
Okay, and do you understand why? Now, I know you take the view that the definition in the Emergencies Act is broader, but would you agree that the threshold to invoke the use of the Emergencies Act should also be a high one?
I would say that with anything, any exercise of power by the state, there is a high threshold. I'm not a legal expert to say, what should be the threshold of the Emergencies Act. So.
Okay, but you understand that the Emergencies Act allows the government to rule by executive order for a period of time.
I do.
Okay, and that the public order emergency section of the Emergencies Act allows those orders to let the government assume control of public utilities, for example.
Yes.
And it allows the government to direct individuals to render certain services, like was done in this case with the tow trucks.
That's my understanding, but again, I do not want to give the Commission the impression that I'm an expert on the Emergencies Act.
Okay. And you understand that it can prohibit travel to, from, or within any specified area? That's one of the things that the public order emergency section allows?
I would say yes, with the same caveat I just provided. Yes.
Okay.
Okay, you're now out of time,
right.
so if
Thank
you
you.
could wrap up,
Just one last question. The placemat that you were taken to by Ms. Khan, that talked about the IMVE, the nature of ideologically motivated violent extremism. Two of those sort of elements were willingness to kill or a willingness to engage in serious violence. Would you agree with me that without those two elements, you just have people who care a lot about something and want to make a change?
I'll answer that question. That's exactly why we developed the criteria as to what should be looked at in this space, in this IMVE space, was to ensure that those criteria were met before we open an investigation.
Thank you. Thank you, Commissioner.
Okay, thank you. We're ready to go. Okay, convoy organizers, please.
Robert McKinnon, Government of Canada. We've just received what I think my friend is going to put up on the screen, and it is not what had been agreed to. It has commentary, it has statements along with the document, if that's what is going to be put up. At least it was just sent around by the Freedom Corp just a few minutes ago.
Lesser version of the one we sent earlier and took out everything except simple facts, sir. There's some documents that are such that I can't just copy and paste them into the document. they're PDFs and things. So I had to type them out, but they're verbatim. So if my friend wants me to refer to each and every document, which I've now made it simple as well, I've had all of them uploaded in one PDF. The clerk has them on standby. As we go through, I have no problem deviating from this at all and going through the document, but I would like to finish the examination, at least if I'm forced to do that, in order to get through these records. These records, there's, in my view, and I would submit as we go through, there's simply no issue with the facts stated herein.
Did you say there is a PDF with all of them on it?
I had that uploaded just now. So I got them, all of them consolidated and put into one PDF so that I can stop wasting.
Why can't we use it?
Well, we can if we want. It's just going to I have to navigate it. Because it's not exactly labeled completely great. So I guess we could, can we use that? Yep, we can do that, sir.
That would be best, I think.
Yeah.
Then we avoid any issues.
Great. Okay. Time to begin now?
You've already taken a fair amount of your time, but I'll be generous.
Just Robert McKinnon again, sorry, last thing. Just as long as the documents that we're referring to, you have, I don't know how many here.
They're all the ones that I've, in the
40.
document that I've given you already. The one.
47. So they're all in relativity.
Pretty much, yeah,
No, no.
all of those are in relativity because that document is in relativity.
No.
So if we could pull up the document, and I just don't want to run out of time.
Okay, so let's see how it goes, and I'll try and keep an eye out for you, Mr. McKinnon, if there's an issue.
Okay, so if I can first, Director, does CSIS have a concern with the current elected executive leaking information and CSIS information to the media? Do they have a current concern about that?
Do you have something specific you
No, I just
refer
want
to?
not specific, but does CSIS have a concern generally about the current political executive leaking information from CSIS to the media?
We always have concern when we see information that is, unauthorizedly, made public. I don't know where the source of those unauthorized disclosures are, so I do not have a specific view on your premise. I'm concerned when I see unauthorized disclosure point.
Right. So, but I take it the unauthorized disclosure, it's highly unlikely it's actually coming from your agency. It's not coming from them directly, is it?
I'd like to think that, we have an organization that, has a very high standard for that, but, I would not want to speculate as to the source of potential unauthorized disclosures.
Okay. If we could go to the January 24th tweet of Mr. McGregor. Or sorry, the January 25th one of Alethea Raj. Tweet 14, number 14.
Council, it might be assistance for you in your time. If you know the page reference in that PDF, it'd be a little bit faster. It does not appear to be hyperlinking to the particular.
Yes, I think the hyperlinks didn't carry through when we uploaded. Unfortunately, that happens sometimes. That's why I wanted to use my sheet. Well, in any event, sir, I'm just gonna ask you. I want to bring up then the document. Just a second. I'll just bring it up on the normal document relativity, and I'm going to have to ask for more time. I tried to get this dealt with, and if I was permitted to use the examination sheet that my friend's trying to stop me from, I wouldn't be in this position.
Well,
Mr. Commissioner, I do have this is Bathsheba Vandenberg, Counsel for Freedom Corps. I do have a number that I can give to the clerk if I may.
Okay, go ahead. Anything to speed it up.
The code for the Raj tweet is HRF 401621.
Thank you. And that's also at page 17 of the document that I had put up, actually. So if you want to we can do that. So, sir, do you see that, that tweet there? It's from the 25th. It's retweeting the January 6th event narrative that had been released in the media prior to the convoy arrived.
Well, I'm looking at the screen now.
Yep. Okay. Did you know that that tweet is what resulted in the political executive essentially becoming concerned with the convoy and having internal discussions about the narrative they were going to build? Were you aware of that?
I'm not sure I understand your question. I'm sorry, Council.
Okay. So I'm going to take you to, and sir, I have them consolidated. They're the text messages between Mary Liz Power and as well as Alexander Cohen. They're verbatim in my examination aid. There's nothing added. If I could bring up the examination aid, please, again, and I can use that. And we can just scroll to where it starts with Mary Liz Power. Sir, thank you.
Does council have any objection to the use of the examination, or?
If he's going back to the same document that.
Well, then I'll read it to him. Okay, verbatim. So on January 25th at 9:22 a.m., Mary Liz Power, Issues and Policy Advisor to the Office of the Prime Minister. They have a text message exchange with Alexander Cohen, the Director of Communications to the Minister of Public Safety, okay? And it begins when that tweet is sent. They send it out, all right? And Mary Liz Power sends that text to Alexander Cohen and states, "I'm sure you've seen this, but flagging." Alexander Cohen responds, "Yep. I've been encouraging journalists to take a closer look at who these people are, in brackets, and where their 3 mil comes from, close brackets. Obviously, a light touch given the portfolio." Then Mary Liz Power states, "Do you know if there's anything to be found in that GoFundMe?" And Alexander Cohen replies, "I think it's worth looking into. I've put Mary Wolf on it." Highlighted, well, it was highlighted, and she's obsessed with this kind of stuff. Mary Liz Power replies, "Nice, I'll look into what I can do." Now, can you agree with me from an intelligence perspective that those are two staffers building a political narrative with respect to a national security issue?
Commissioner, there's a lot of information that has been put to us now. I have not read those tweets before. I could not make any informed, opinion of what this information is in the context of today's hearing.
And then later that day at 12:02 p.m., Mary Liz Power and Alexander Cohen exchange further text messages, all right? So Mary Liz Power states, "Got a quick response. People are into it. LMK, meaning let me know. If your boss is too. Happy to help however I can. This is what I sent, though, by the way." And this is whoever she sent it to with respect to the narrative. "Hi, I just had a chat with Alex at PS, who had a bit of an interesting idea. As you saw in the pod goals chats, the trucker convoy and some of their more extreme comments, in brackets, i.e. calling for a January 6th style insurrection, close brackets, are getting more coverage in media. Alex was surveying where there'd be interest in his boss, that's the public safety's minister, doing some media on this eventually. He was chatting with Vigneault about right before he went into the cabinet retreat. I think there could be an opportunity in getting in on the narrative of the truckers, particularly with the research that the LRB is doing into their backers. My thoughts of framing here would be similar to what the PM and Blair said last year when January 6 occurred. Our democracy is something we need to nurture and protect every day. We will always protect the right to peaceful protest. Some calls that organizers of these events are making are concerning, and we're taking them seriously. We'd need something to back this up in brackets. We'll continue to monitor the situation closely, and the fine line to walk would be to ensure we are not looking like we're directing the police, which obviously is not the goal here. Hoping to canvass your thoughts. Alex said he'd come back to me with a proposal this aft when he gets to chat to Mendicio again, and obviously pending his boss and our interests in looking into this further. Mr. Cohen responds, thanks. I had an initial chat with my boss and he's supportive, but wants to wait a day or two. There's a danger that if we come down too hard, they might push out the crazies. Mary Liz Power replies, I think that's fair. Apparently Global and others are working on stories. Maybe we see how those land. Now, I'm going to ask the same question again. At that point, are there a bunch of political staffers essentially planning to create a national security issue or make one look like it is?
Mr. Commissioner, I will have the same answer. You know, there's a lot of information just been put to us for the first time. There are acronyms that were mentioned. I don't know what they refer to. And I think, you know, I could speak to information I'm aware of, privy to, but unfortunately not this one, Council.
So are you aware of the LRB, what it is? You are, aren't you?
Not the specific acronym, maybe if you spell it out.
Liberal Research Bureau.
Yeah, I know about the Liberal Research Bureau.
All right. And so is it fair to say that it's kind of strange that the political branch would have the Liberal Research Bureau doing research on protesters with respect to these concerns they're raising, as opposed to yourselves who are the National Security Agency?
Mr. Commissioner, I would say that, you know, this is not something that would be of interest to CSIS. As we, my colleagues and I have testified, we very much, you know, since the beginning, mid-January on, we've been looking at these issues and the developments and potential threat to the security of Canada based on the CSIS Act. So we would not be looking necessarily for what other parties would be involved in this context.
Okay, can we go to document ssm.can.00006358 underscore rel.0001. Okay, can we just scroll to the bottom to the first email, please? Okay, so this email is from January 27th, okay? And it's an email between, again, more political staffers. It begins with Carolyn Williams. She's the Director of Parliamentary Affairs at the Privy Council. You're aware of that?
No, I do not know Karen Williams.
And what about Zita Estrava, the Chief of Staff to the Minister of Emergency Preparedness, Bill Blair? Do you know her?
Yes, I do know Ms. Estravas.
And Annie Cullen, she's with the Privy Council as well. Are you familiar with her?
No, I'm not.
Okay. So in this email, and again, it's January 27th, 2022 at 4:21 p.m., you're aware that the protesters in Ottawa hadn't really even arrived at that time, right?
Sorry, on the 27th specifically, I do not have those specific chronological details with me. I'm sorry.
So there it says to ML, that's Mary Liz, I wanted to reach out on the current issue lead situation for the convoy. Given how this is transitioning to a whole of government coordination response, I feel like emergency preparedness, we are well-positioned office to provide more of a high-level messaging going forward. Public safety, of course, has a major role to play when it comes to the RCMP, CSIS, and IMVE threats. But we have a helpful perspective on the whole government coordination and collaboration with other levels of government. These are the lines we worked up earlier today. Any thoughts on if this is a helpful approach? Convoy, emergency preparedness. And it says, our government recognizes and respects that everyone in Canada has the right to safe and peaceful protest. Threatening acts of violence and inciting hatred, as we have seen from a select few in recent days, is unacceptable and does not reflect the views of the majority of Canadians. We condemn all such hateful and violent rhetoric in the strongest terms. As is common with any significant gathering with potential impacts of government operations, such as the annual Canada Day celebration, law enforcement and security agencies across all levels of government are engaged in coordinating to ensure a safe event. Now, do you recognize the phrases and the sentences in the first 3 bullet points? Have you heard them somewhere before?
I do not have a specific recollection of these words.
Do you recall the Prime Minister's speech on January 31st? Do you recall him when he was in isolation? He came out and gave a speech on January 31st about the protest. Do you remember that?
I do not remember the specific date. I remember having the Prime Minister speaking, to this effect when he was indeed in isolation.
That's what he said.
Okay.
So he said, can you agree with me that writing out a narrative like this prior to the protest even arriving, and then on the January 31st, despite the fact, and this is in evidence, there had been no real actual violence in Ottawa, he says these things. Do you find that concerning?
From what point of view?
As an intelligence officer, as an intelligence agency, that there's a narrative being built for an emergency before the purported thing creating the emergency has even taken place.
Mr. Commissioner, what I can say is that as we've testified, the interdepartmental community got together to understand what was happening, share information, make sure that each of the organization would be able to discharge their mandate appropriately. And so at that point, of course we are, as I testified, we're keeping aware of what's happening around us, but we are very much focused on making sure that we are discharging our investigative responsibilities and not opine on other issues.
Okay, and let me ask you this. The biggest concern, it appeared, was over the first weekend of the protest. There was the appearances of Confederate flags and Nazi symbols, right? Did you investigate those issues at all?
Mr. Commissioner, we testified earlier that we have written an intelligence assessment about the presence of flags and some of the meaning of those flags. And so I can go back to our analysis, what we've described then. I'd be happy to, if you want to refer me back to the document, speak to that.
Okay.
Concept.
Now, Mr. Clerk, if you could just go back to my examination aid, this shouldn't be an issue. It's at paragraph 16, just scroll right down to it.
So, Mr. Commissioner, just for your information, this is the document that the DOJ has an outstanding objection over.
And if we can go to paragraph 16.
Mr. Commissioner, we've already objected to this document being put up.
I understand, but I'm going to ask for a ruling on the commissioner to put this page to them. So let's deal with that if we can. So if we can put up page 16 again.
And what is page 16?
Or paragraph 16 is just the two pictures of the first post in time at 10:13 a.m. on January 28th, 2022 of the spotting of a Confederate flag. And there's also a license plate number. If you'd like me to go through and bring up all of the documents, I'm just trying to get this done quicker, sir.
Well, you're way over time already.
I understand, but this is so important, sir, that I need more time to get through this area. It is extraordinarily important.
Well, so far asking a bunch of questions to people who have no knowledge of the documents or the information is not, I'm trying to explain something. Yes. And I know you're frustrated, but that's not good use of your time. And reading into the record that exchange of texts was done days ago. And again, that's not a good use. So I'm just, I'm trying to be patient, and I understand you want to get something done. So let's try and work together to figure out how we can navigate this in a appropriate way.
Okay.
So you want to put up a picture of a license plate that's in relativity?
Yes.
Okay, and I think your co-counsel has the number for that, the relativity number, so we can, I'm guessing.
Yes, Mr. Commissioner,
Okay.
from my understanding, Mr. Miller would like to first put up a tweet of Ariel Truster that shows the image of the license and then the license. So we'll call up the number HRF, so POE.HRF 6021.
So I think that's okay, Mr. McKinnon. We're just putting up the picture for what it's worth. We'll see what it is.
We've gone to page 16 with respect, and it's not just a picture.
We're not putting up page 16.
We've moved on, Mr. McKinnon, so
if it's just the picture, that's fine.
Okay, so that's what I think we're doing. So I'm just let's try and get through this.
Okay, so, sir, this is my first understanding that this was the first post in time that I can find with respect to when a Confederate flag or a Nazi flag appeared. And it's at 10:13 a.m. on January 28th of 2022. And it's posted by Ariel Troster. Do you know who she is?
I do not.
You're not aware that she's the new counselor that replaced Counselor McKenney?
I do not know who the individual is.
All right, and so then if I could just bring up the closer photo with respect to the license plate, please, and that actually is at page 43 of the examination book of authorities. That'll just be easier for you, Mr. Clerk.
Well, no, I don't think we go there. So your co-counsel, I think, has the reference.
Yes, Mr. Commissioner, the reference is POE.HRF 6029.
So, and it's been clear, so online, that license plate number is BL, then it's got a crown in the middle, is 3, and I can literally tell you what it is, and people were trying to look it up. It's viewable. Did at any time CSIS do an investigation into who that license plate holder was?
Mr. Commissioner, I do not have the specific knowledge of this, and even if I had specific knowledge, we would not be at liberty to disclose specific details. Right. That's why there was an in-camera session with the Commissioner and Council.
Okay, and so the next document then would be the, second please. The next document is the one that comes after in the examination aid, and it is the January 29th being POEHRF 0000000024.
Okay, you're going to have to wrap up, though. If these are just pictures you're putting up, you can put it up with any witness.
I understand. So the next time a Nazi flag or a swastika or whatever you appears.
The next time you've found it. I mean,
right,
I think.
Right, the next time, so you knew about the situation where Conservative Party Member of Parliament, Mr. Cooper, he was giving an interview and this upside down Canada flag with the swastika appeared. Are you aware of that?
I remember something to that effect. I've not researched this recently, but I recall something to that effect, yes.
Okay. Could I now bring up POEH.HRF 00000026? Okay. So this is the post from a fella by the name of Skip Pop, unidentified on Reddit. He posted at 3:12 p.m. And it's, from my understanding, the first time that the Nazi flag photo appears. Are you aware of that?
I'm not aware of that, and I'm not seeing
Yeah, it's just
anything other
I'm
than
just trying to get through it. And then there is the issue with respect to that, that no one was able to identify this gentleman. And I believe there's a close-up photo of my friend, Ms. Vanberg.
I think that's going to have to be it, though.
Right. Well, I'm just going to, if we're going to run out of time, is this. Were you aware that the first time that the picture of the gentleman all covered in army fatigues with a mask over his face, walking with a Confederate flag through a crowd, it first appeared in an opinion piece in the Toronto Star from someone who actually works for the Liberal Party of Canada? Were you aware of that?
Mr. Commissioner, my friend seems to be giving evidence now.
I'm asking if he's aware of
He
it.
asked a question, and I can guess at what the answer is
Right.
going to
Right,
be.
okay, but there's a presupposition of a fact that's not it.
Yeah, because you keep interrupting me when I'm trying to ask questions and I'm running out of time.
Just, please. Okay.
So
I'm not aware of the articles, and I'm not aware of those facts that you mentioned. Right. I'm sorry.
Are you aware of a company called Enterprise Canada?
Not specifically, no.
And have you identified the individual, one that it was all over the news, the gentleman that was carrying the Nazi flag? Have you identified him yet?
Mr. Commissioner, as I've said before, the specific details of our investigations have been shared, with Commission earlier. I would not be able to go into more specific details.
Okay. So I think that's it.
Right, yeah. No, and I
Thank
take it then, sir, that you know that individual was Brian Fox from Enterprise Group.
I have not said anything of that respect to council. I have not testified to that, council.
Yeah, you haven't testified to it, but you know that to be true, don't you?
No, that's not fair. Firstly, not a fair statement. So please, and please don't, if you're going to make a statement, please make it. Don't make statements back to the crowd as you leave the podium, please. As council, you're well aware of the appropriate way to conduct yourself. Okay, next, I'd like to call on the Canadian Constitution Foundation, please.
Good afternoon. My name is Sujit Chaudhary. I'm counsel for the Canadian Constitution Foundation. I wanted to ask you a few questions about the legislative history of Section 2C and the emergence of IMVE as a central focus for CSIS's activities, if I may. So is it true that Section 2C was amended in 2001 by the Anti-Terrorism Act to include a religious or ideological objective?
I believe so. I believe that's accurate.
And is it true that that amendment was ensured that the CSIS Act would align with the criminal code's new definitions of terrorism?
I wasn't involved in that, so I don't want to lead you in error, so I'm not certain.
Mr. Vigneault, you're shaking your head.
Same answer.
Okay, all right, fair enough. And so I'd ask you to take my word for it that it was part of the same legislative package to get those two statutes in alignment. And then in 2019, there is a major initiative on the part of CSIS is the development of a definition and framework for ideologically motivated violent extremism. Is that right?
I believe that the work started before that, but I think it was maybe put in higher gear. I had
in my first public speech that I had made after becoming director in 2018. That speech spoke to the rise of this, and I believe I used the concept of IMV then, but it's around 2018, 2019 indeed that work was solidified and the concepts were developed to try to understand, characterize better this new phenomenon dynamic we were seeing in society.
Good. And sir, and just so we're clear, I believe that the first time CSIS reported out on this development and its thinking was in the 2019 annual report.
That sounds accurate, yes.
Okay, good. And is it true in your interview summary you stated that IMVE does not mirror the criminal code definition of terrorism?
I don't recall seeing that. You'd have to show me the document.
Sure. So could we pull up witness summary 60, please? And could we go to the bottom of page 3? Thank you. If we could expand, yes, that's very helpful. Thank you. Okay. So, Mr. Vigneault, do you agree that you said here that the definition of IMVE does not mirror the criminal code definition of terrorism?
I'm just trying to look at it here. Is it the last sentence?
Yeah, it's the last. It start at the third line from the bottom, sir.
Yes.
Okay. And then if you could continue, you could just continue to. You said you gave them the example of Alexandre Bissonnette, who met the services definition of an ideologically motivated extremist, but who was not charged with terrorism offenses under the code. Did you say that?
Yes.
And so is it reasonable to infer from your evidence there that the definition of IMVE is broader than a criminal code definition of terrorism?
I'm not sure I would say it's broader, but it's for different purposes for sure. And I think I'm very familiar with the attack at the Quebec City Mosque, and this example and other unfortunate examples is what forced CSIS to say this dynamic. We need to better understand what is happening. So that work to better define IMV, the 4 quadrants, and so on, was in relation to that. But it's also very important in this comment when I say that it was different than the criminal code, is that you could meet a definition of threat to security of Canada under the CSIS Act.
Sure.
You could meet the sociological definition of terrorist activity, which I believe that Alexandre Bissonnette was indeed engaged in terrorist activity, but that may not transfer the Crown charging someone for a terrorist offense. And I think it is a very important notion that indeed has been, very troubling for many in the country, including in this specific case, the Muslim community in Canada.
So does it follow, sir, from what you've just said, that IMVE or the notion of IMVE gives CSIS broader tools to assess and respond to extremism than might be available under the criminal code?
I think by statute, CSIS has been built to be separate and distinct from law enforcement and from the criminal code, in the sense that our threshold for investigations would be different than the police. Our techniques might be also different. So I think it is clearly separate, the two.
And sorry, ma'am, did you?
No, I think that's a very accurate response.
And would you say that it's that CSIS over the last number of years has developed a lot of expertise on IMVE?
I would say yes, because unfortunately there are more cases in Canada, there are more cases internationally, and we have worked very closely with a number of partners at the federal, provincial, municipal level, and international partners. And as my colleague testified, that conceptual framework has been adopted by a couple of international partners as well.
And the analysis is done in the first instance by skilled intelligence professionals?
Yes, that would be accurate.
And you're a learning organization, so you're always trying to improve how you analyze IMV.
That would be accurate, yes.
Okay. And so would it be fair to say, if you can now look back to 2018 or 2019 and think about the world before then and the world after in terms of CSIS's function, do you think that the adoption of IMVE has broadened the scope of the activity CSIS investigates under 2C?
I would not say they broaden. I would say that they help our investigators, our analysts, to better understand of how the CSIS Act applied, what would be the, because again, we make a very significant distinction in what we call awful but lawful speech and protected, by the charter versus activities that would be, defined under the CSIS Act. And so I think it's not a broadening, it's more a fine tuning of the understanding, developing analytical tools to make sure that not only do we not go over the law, but that we are indeed investigating the threats to Canada as mandated by Parliament.
So, but you would agree that IMVE now occupies 50% or more of CSIS resources?
Of our counterterrorism resources, yes.
Mr. Commissioner, how much time do I have left?
You have about 2 minutes left.
Okay. I'd like to pivot at the end just to the issue of threats to government officials online, if I may, because my friend Mr. Champ raised it for you. And so it seems to me, and I ask you to agree with this, that it seems that the mere utterance of a threat online doesn't necessarily per se cross the Section 2C threshold. Is that right?
Yes, that would be accurate.
Yeah. Could you tell us when it would?
I think as we try to maybe unskillfully try to exchange previously, the analysis, is based on the best way possible to describe it is what we have on this placemat. These analytical tools have been developed to make sure that, at all levels of the organization, but also more broadly within the community with law enforcement who are themselves in their own jurisdiction trying to understand what is happening and make a distinction between something that would be bravado online, that would be something that should be investigated, under the criminal code by law enforcement, and something that we CSIS would be doing. So it's probably the best way of describing it, which is maybe not helpful for your purpose.
Okay. Well, Mr. Commissioner, I think we're out of time. So thank you for your time.
Thank you.
You actually had a minute left, but I don't. Okay, so I think probably we'll take the lunch break now and come back, because I think we should have a little over a half hour of time left. So let's come back at 2 o'clock, please.
La commission is in recess until 2 o'clock. La commission est levée jusqu'à 14 heures. Order à l'autre. The commission is reconvened. La commission reprend.
Okay. Bon après-midi, good afternoon. I think the next is the Union of British Columbia Indian Chiefs.
Good afternoon. My name is Cheyenne Arnold Cunningham, and I'm counsel for the Union of BC Indian Chiefs. I will be directing our questions today to Mr. Vigneault, but I welcome the answers of any participant on the panel who may be able to supply additional information. Mr. Vigneault, are you familiar with Bill C-15, which received royal assent and came into force as federal legislation on June 21st, 2021, to adopt and implement the United Nations Declaration on the Rights of Indigenous Peoples, also known as UNDRIP?
I'm generally aware of the bill, yes.
So under that legislation, the Government of Canada is required by Parliament to take all measures necessary to ensure that the laws of Canada are aligned with UNDRIP. How is CSIS meeting this obligation?
That's an interesting question. I think that our work as an organization, we're supporting the government, continues to be making sure that our specific act is respected, that we are, of course, respecting the law, but at the same time that as an organization that we are taking measures and steps internally to make sure that we will live up to our obligation on human rights. I do not have a specific reference to the CSIS Act in relation to UNDRIP.
Okay, that's what I was going to ask next. We noticed in your mandate letter that you've been mandated to advise Minister Mendocino on deficiencies within the CSIS Act that require modernization. So I just wanted to confirm if a review of the CSIS Act for alignment with UNDRIP has been prepared within the agency.
There's been no specific review of the CSIS Act. We have been advocating in my transition advice to Minister Mendocino. I have advised that the Act is close to 40 years old and the world has changed very significantly. And in order to make sure that CSIS was not only able to discharge its national security mandate, but also make sure that we're doing so with the evolving expectations of Canadians vis-a-vis an intelligence organization, that there was a need to modernize the Act. There's some internal discussions at the moment in that respect, but there's been no specific legislative amendment introduced.
Okay, thank you. Does CSIS consider Indigenous rights in conducting its assessments and evaluations?
Actually, we do. And there is one specific document that I have in preparing for the commission's work that I would like maybe council to bring up that in relation to our analysis.
I believe the document that Mr. Vigneault is looking for is ts.nsc.can.002502225.
Okay, great. Thank you so much.
Can we? Sorry, I'm sorry. Is it going to be pulled up? Sorry.
I'm going to make note of that document and I'll take a look at it. But I'd like to move on to the next question for.
I'm sorry. There's just one specific element. If you go scroll down, scroll. So there is just before go down. Sorry, you're going too fast. Okay, stop, please. So if you look at the last paragraph here, this is something that I'd like to point out, that as an organization, we are obviously not perfect, but I'm very proud of the work that the organization is doing to be aware of how our activities can potentially, impact people. And so the quote here is, despite the lack of concerted Indigenous support for the Ottawa protest, any law enforcement response must be culturally sensitive in an effort to negate any backlash from the broader Indigenous community. And this is, I think it's important to bring this on the record because, as I said, we're not a perfect organization, but we try very hard to make sure that we understand how our actions are perceived because, again, we are an intelligence service that works in a democracy, and we want to make sure that our actions are specifically directed towards threat-related activity and not unduly to other groups.
Okay, thank you. Branching off of that, thank you for bringing that up. Has CSIS considered whether UNDRIP's implementation means that there should be distinct considerations on CSIS's ability to monitor nonviolent and unarmed First Nations people who engage in activism pertaining to their lawful rights, even in situations that are perceived to be public order or emergency events that are allegedly unlawful?
So, as I mentioned earlier, we have not done a full analysis of the intersection between the CSIS Act and UNDRIP. What I can say is that, as I think testament to the document I just pulled out there, we're trying to really understand how we can discharge our mandate as directed by under the law that Parliament has given us, but make sure that we do that in a way that is sensitive to how a lawful protest, including in your question, Council, the Indigenous protest, is taking place. We have testified that we cannot monitor, investigate lawful protest and dissent, and our analysis, of events always takes that into account. That is not to say that we will not be, of course, in order to make a determination if there is a threat to security. Of course, we look at a number of different issues, and I think there were some documents that recently were released on the Access to Information Act that concluded that CSIS advised government that maybe some Indigenous protests did not constitute a threat to the security of Canada, which is, I think, an important point to make sure that people understand when there are potentially law enforcement action, they understand how we see it from our own mandate's point of view.
Okay, thank you. And I'm going to wrap up with just a few last questions. So in your mandate letter in May 2022, Minister Mendicino mandated that CSIS must work to eliminate any systemic racism or unconscious bias in its operations. He specifically made reference to ensuring that, quote, minority communities, unquote, are not subject to unfair scrutiny in the name of national security, and that CSIS, quote, ensure the intelligence and evidence used when making determinations are free of bias, prejudice, and up to date, unquote. What work is CSIS doing or planning specifically to eliminate anti-Indigenous discrimination in its operations, monitoring, intelligence gathering and analysis, or reporting to other government branches or agencies, specifically in the context of Indigenous rights defenders?
I would say that there are probably three main aspects of our work. The first one is, I think, as exemplified by the document I pulled out, our intelligence professionals within the organization are trained and continue to receive training to better understand, how the work that they do might be perceived, how it would impact, different communities differently, and to make sure that they have this awareness. So that the aspect of training is an important one. The other aspect is, as an organization, in terms of our management of our organization, how do we make sure that we bring diversity, that we continue to work to have a much more diverse organization, that we understand that, some of our policies and procedures might not intended to be biased, but the net effect might be systemic racism, and we want to understand how this works, and we take measures to correct that internally in our own procedures. And finally, I would say we have launched a very specific stakeholder outreach program to make sure that we understand and we meet with communities that we had the chance personally early in my tenure to meet with the Assembly of First Nations to establish some contact, some ability to talk to each other. So if there are any concerns, any issues, that we have those lines of communications open, because it is very complex work that CSIS professionals do, and we want to make sure that we understand how it is being received and perceived by the population we serve.
Okay, and last question. Do you have any specific Indigenous officials working in those advisory positions, whether it be an advisory body, an internal committee, or just an advisor to advise on matters such as making sure, surveillance of ideologically motivated activism doesn't suppress legitimate activism by Indigenous peoples regarding their rights?
I would point out to two specific bodies, if you want. One is an internal one. It's called the Black Indigenous Persons of Color Congress within CSIS, the BIPOC Congress. So I personally meet with them. The last meeting was probably a month and a half ago, where we are sitting down and looking at our specific strategies, plans to make sure that we get their input before it is our policies are changed. So we want the input, we want co-development of some of these approaches.
So that is an internal one. And the second one, I would say, is not as much an advisory body, but the fact that our activities are reviewed by two specific agencies, the National Security and Intelligence Review Agency, and CIRA, and the National Security Intelligence Committee of Parliamentarians, NSICOP. Both organizations have access to all of the specific classified details of our operations, and are looking at our ability to make sure that we not only respect the law but our procedures. And NSICOP in the last couple of years has indeed looked at how the security intelligence community was engaging with communities, and how we were making efforts to be a much more diverse and inclusive organizations.
Okay, thank you so much for your time today. Those are all of our questions.
Okay, thank you. Next, call on the Ottawa Police Service.
We have no questions. Thank you.
Okay, thank you. Counsel for former Chief Slowly.
Thank you, Commissioner. Rebecca Jones for former Chief Slowly. We have no questions.
The province of Saskatchewan, please.
Yes, good afternoon. My name is Mike Morris. I'm counsel for the government of Saskatchewan. I'd like to start out by discussing CSIS's February 13th draft threat assessment. So I'm going to ask the registrar to pull up the document. It's TS-NSC CAN 001 50172. Mr. Vigneault, just as we're waiting, this document is entitled Possible Implications of Emergencies Act Across the IMVE Space. I gather you're familiar with it. Is that fair?
Yes, I am familiar.
The clerk of the Privy Council mentioned last week that this document was available to attendees of the February 13th cabinet meeting. Do you recall it being distributed?
My recollection is that the document was discussed at the earlier that day at the IRG meeting, and the document was made available to the Privy Council office, who is charged with cabinet materials, cabinet documentations. So I do not have personal knowledge if the document was distributed, but I am aware of the clerk's comments last week.
You attended the cabinet meeting on February 13th, correct?
I did.
I guess my question is, would you expect to have received notice from the clerk that this document was being made available or distributed for that meeting, if it was?
I was aware that we CSIS were asked to make the document available to PCO, so I knew that the intent was for the document to be distributed. I just do not have the personal knowledge if indeed it was, because the meeting was obviously scheduled, fairly quickly that Sunday evening.
Right. Would all attendees at cabinet have had the security clearance necessary to view this document?
They will all have the right to see it. Ministers do not have security clearances. As privy councillors, they are deemed to be to have access to the classified information. So yes, they would. Every member of a cabinet would have been entitled to see that information.
Okay. To the best of your recollection, was the content of this document related fully and accurately at the cabinet meeting?
I do not remember the document being discussed specifically.
Okay. I'm going to quote you a statement that the clerk of the Privy Council made in her evidence on Friday. So I want you to just listen closely. If we need to pull up the transcript, we can. The clerk stated, Cabinet was aware that CSIS had not assessed a threat to the security of Canada necessary to trigger their authorities under the CSIS Act. Are you able to agree with that statement?
Yes, I'm able to agree because I had been part of previous meetings. My colleague, Madame Tessier, has also been part of meetings when we were providing that assessment to Cabinet. So it had been provided, a few times. And as we testified to earlier, this was a dynamic assessment. So it's not because we came to that position earlier that we would not change. It was when it was reiterated to Cabinet, it was the assessment of the day that continued to be the same thing. So I'm very comfortable to say that Cabinet was aware of this assessment.
Okay, thank you, sir. I want to move on to discuss the ability of the federal government to sort of disclose CSIS's bottom line assessment to provincial governments and premiers in particular, because we're aware that there was a First Ministers meeting on the morning of February 14th. And I'm interested in whether CSIS's bottom line conclusions would have been able to be disclosed at that meeting. And I want to put two of those bottom line conclusions to you, sir. One is that CSIS's assessment that the protests did not pose a threat to the security of Canada as defined in Section 2 of the CSIS Act. Would the federal government have been at liberty to disclose that information on February 14th at the First Ministers meeting?
I would say that probably not, because the CSIS Act under Section 19 is fairly restrictive in terms of who can access classified information. And so that access does not go to provinces, territories, or municipalities. So that would be my, I was not part of the specific meeting, but for the purpose of this discussion, that would be my reaction. Section 19 will not allow the classified information to be shared.
Well, if there was information of a threat, for example, in the province of Saskatchewan, how would that information then be conveyed to the provincial government? Somebody must have the authority to release it. Is that fair?
So the way that information, threat information, operational information is relayed is through between CSIS and law enforcement bodies in this context. It would be RCMP. We referred earlier to a construct called Integrated National Security Enforcement Teams that exist across the country that allow different levels of law enforcement to receive the information. So that's normally how the classified threat information will be relayed.
Okay. I just have a couple more questions. We heard some evidence the other day that the NSIA asked the RCMP to produce a threat assessment for the use of the Clerk of the Privy Council on February 14th. I'm wondering, was CSIS asked to prepare a similar threat assessment for the Clerk of the Privy Council on February 14th?
I do not recall such a request. I have seen the testimony, and as part of the preparation for this appearance, I've seen an exchange of email that was in reference to that threat assessment. I do not recall that day being asked specifically to do such an assessment.
Okay, I just have one final question. This one's more of sort of personal interest, and it's to Ms. Tessier. Ms. Tessier, you've had a lengthy career with CSIS, and I understand that you would have been employed with CSIS following the September 11th attacks. Is that correct?
Yes, that's correct.
We've heard that CSIS's threat assessment remained at medium throughout the Freedom Convoy. Can you advise whether CSIS's threat assessment exceeded medium in the period immediately following the September 11th attacks?
I'm going to have to refer, because the national threat assessment level is assessed by ITAC, so I'll refer that question to my ITAC colleague.
Thank you. It would be very difficult to say. The ITAC was created in following a 2004 policy, a national security policy, so it was not in existence right after the September 11 attacks.
Maybe if I could add to that, Council, Commissioner, I would say that to my knowledge, the first time that the National Terrorism Threat Assessment was created was in 2014, and so to the best of my knowledge, it did not exist in the aftermath of 9/11.
Thank you for answering my questions.
Okay, thank you. Next is the Government of Canada, please.
Good afternoon. I'm Robert McKinnon for the Government of Canada. I just want to clarify first the document that my friend put to you just a moment ago. It's actually an attachment to the cabinet minutes in a different document ID. If you want to pull it up, you can see it SSM NSC.can, number of zeros 216, page 12. Is that the assessment that my friend just put to you?
Yes, it looks to be it, yes.
And if you scroll up a little bit, you'll see it's part of the minutes from cabinet meeting. So that would have been distributed as part of the cabinet. Is that right?
Yes, yes, it appears so.
All right. On another question that Mr. Miller put to you, he put to you questions suggesting that it was only on or after January 25 that there were concerns about threats and extreme ideologies in connection with the convoy. Do you recall that?
Yes.
You have also testified that CSIS was receiving the OPP's Project Hendon reports and participated in the Joint Intelligence Group in relation to the convoy. Is that correct?
Mm-hmm.
Okay, I'd ask that you pull up the document OPP 401606. This is a Project Hendon report dated January 23rd. And if you go to the second page, okay, stop. If you look at the paragraph that starts the third, we assess the commercial truck drivers participating in the Freedom Convoy are likely to be generally supportive of holding a lawful protest. However, convoy supporters may include individuals representing ideological movements who may view the protest as an opportunity to advance their own causes or beliefs. Some of these individuals may engage in activities that are not sanctioned.
Can you just slow down a bit, please, in your reading?
Sure. That are not sanctioned or supported by convoy organizers in order to achieve their own objectives. The post on the Rise Up Durham website referencing Ottawa being wild, which echoes the language used by former U.S. President Donald Trump prior to the 2021 attack on the U.S. Capitol, tends to support this hypothesis. If accurate, then this assessment could indicate the possibility for conflict between a larger group comprising commercial truck drivers and a smaller group of ideologically driven opportunists. Do you see that?
Yes.
And you would have received, or CSIS would have received in their regional offices and agencies this Hendon report of January 23rd. Is that correct?
That's my understanding. Yes.
I'd also ask you to pull up OPP 0001608. It's another Hendon report dated January 24th. And just the first bullet point, if you can go up a little bit, yes. You'll see it says, Diagolon content has been posted or pinned on some social media sites promoting the Freedom Convoy. Some Diagolon adherents are indicating an intent to attend the event in Ottawa. We have not yet identified any comments from convoy organizers disassociating the convoy from Diagolon. Diagolon flags were also observed at a pro-convoy rally in Sudbury on January 22nd. And then if you go over the page to just above tactical considerations, the range of anti-authority movements supporting the convoy, the presence of Diagolon insignia on convoy social media sites and at the Sudbury protest, and the potential attendance of supporters from the line at the protest in Ottawa validate previous assessments that noted the use of the Freedom Convoy by actors who may be willing to engage in acts of public disorder and possibly violence. Do you see that?
Yes.
And that information, again, would have been received by the CSIS regional offices and all recipients of the Hendon reports on January 24th. Is that correct?
I would have to assume so.
And the last one, document I'll take you to ts.nsc.can.001. And then a number of zeros, 156. This is an ITAC threat assessment of the possibility of IMVE-driven violence on the margins of the truck convoy protest. So this one's dated January 26th, before the January 27th date in the email that my friend took you to. So if you look at the second paragraph, while this is intended by the organizers to be a peaceful protest, open source reporting indicates that prominent ideologically motivated violent extremism actors in Canada have seized upon this protest to advocate for their own ideological objectives, and some have expressed interest in attending the protest in Ottawa this coming weekend. So again, this would have been received by CSIS's regional offices and well, it's created from ITAC itself. So and that, well, you can speak to that, Ms. Shayer. Is that correct?
Yes, we published that document on January 26th, and it was distributed to our ADM and SOPS colleagues, so the broader National Security Committee in the federal government. And the next day, we published an unclassified version, which was made available to our security colleagues in other jurisdictions.
So all these reports, would they not indicate a concern about violent extremist elements attending or being part of this convoy?
So our assessment pointed to a number of possible scenarios. We talked about the possibility of INVE voices, if you will, leveraging the event to push their own narrative, their own violent narratives, and potentially recruit and incite violence. We also talked about the possibility of this event and a very, very present narrative of some IMV-inspired people, which could potentially trigger vulnerable individuals to mobilize quickly to violence and then conduct an act of terrorism.
Okay, I don't need that document anymore. This one's for Mr. Vigneault. You were asked a question earlier today, and it's also you gave an answer that's also in your summary of the in-camera testimony when about your support for the invocation of this act, the Emergencies Act. And you said, based on your understanding of everything you had seen up until that point, do you recall that?
Yes.
Can you detail what you had seen or been informed of that contributed to your opinion that it was necessary to invoke the Emergencies Act?
Essentially, our information that we've testified to is an evidence with the fact that we knew there were ideologically motivated violent individuals who were interested in this event. The unpredictable nature of this event, the fact that it had gone through different phases and its size and scope continue to be, both in Ottawa and across the country, continue to vary. Spontaneous or not so spontaneous events, blockades, and so on. Fact that law enforcement resources were being diverted from different sites to potentially deliberately to make sure that there were less capacity to deal with these events. Fact that we, as part of the many interdepartmental meetings I attended, information from the CBSA, from Transport Canada, from Finance Canada, about the impact
the disruption, the protest, the blockades were taking the country. And the fact that there was an evolving operational plan by law enforcement that at that point had not yet been put in place to be able to deal with this situation. All of these elements of unpredictability, based on my experience, having been around national security issues for quite a few years now, led me to believe that the regular tools were just not enough to address the situation.
Okay, here's another question concerning the decision. Did the GIC have the same inputs that CSIS had when it made its decision and CSIS made its decision under its act? Are you aware whether they were exactly the same inputs?
I did not have full access to, necessarily the documents that the GIC was presented. What I can say is that I had been part of personally, or my colleague, Madame Tessier, had been part of the cabinet discussions, the IRGs. So I had I would say a very good understanding, but I could not characterize it as being perfect information necessarily.
Right. I'll take you to briefly the summary of the in-camera proceeding that a couple of council have taken you to, just to look at a couple other paragraphs. So if you could pull up WTS 6079, page 4. So where it says in the paragraph, Ms. Tessier explained, that's right, that unlike RMVE, IMVE groups often do not have a command and control structure or organized membership. Now, we've heard that said today. Could you you mentioned networks, but perhaps one or other of you could just explain just quickly the difference.
Yeah, certainly. As I mentioned earlier today in my testimony, in the past, I use Al-Qaeda as an example. There was very much an organized structure. Not anybody could adhere to Al-Qaeda. Whereas today, especially given the internet and the ability to network together on social media, there is difficulty in just comparing it to what would have been the case in the past, where you had a physical presence, you had to be vetted to be part of this group. Not to say that there are some IMVE groups that don't do that, most certainly there are, but given the vastness of communications today, especially on the internet and various social media sites, the ability to get to know individuals who share your extreme ideology is a lot easier than it would have been in the past. And so that's why we prefer to call them networks. And we referred to lone wolves earlier, how one person can commit an act. They don't necessarily have to be directed to do so. They weren't necessarily vetted by anybody, but they adhere to this network. And that's just but one example in terms of what we see today.
If I could ask you to turn to page 8. Under threat assessment concerning invoking the Emergencies Act, if you could look at the paragraph that starts, Ms. Tessier explained that there was an initial increase in online rhetoric after the invocation, but because it was announced at the same time as public health measures being lowered, the increase petered out. Is that correct?
That's correct. That's our assessment, yes.
So it wasn't as aggravated as perhaps the assessment first foresaw? Is that?
I would say that's very specific to the Emergencies Act itself, but we have most certainly seen, as I testified to earlier, an increase in anti-authority rhetoric.
Okay. And because I may not have time to take you to some of these ITAC assessments that are referred to in the next paragraph, can you just confirm that the summary there is accurate, that it says the panel will refer to several CSIS and ITAC assessments between 2020 to the period the convoy ended, describing threats to journalists and politicians. The panel agreed that since 2020, there has been an increase in IMVE online rhetoric and threat to authority figures, including law enforcement, public and elected officials. Ms. Shire explained that this rhetoric was mostly targeted towards politicians, including as against provincial officials and the Prime Minister. You see that? Do you have any sort of further comment on that threat environment from 2020 to today? Has it changed in any way, or has it remained the same?
I would say it is increasing, and I'll pass to my colleague as well, but I would, from the CSIS perspective, part of the concern is you're seeing a lot of this type of discussion in more mainstream media. And we know through some of the individuals that we would be concerned with, and as I mentioned a number of times today, they try to use that to recruit individuals towards a more extreme ideology. So because we see a lot more of this globally, frankly, adherence to this type of a movement, it is of increasing concern in terms of the ability for people to access that type of violent propaganda. I don't know if my colleague...
I completely agree. I would also add that we have seen during the pandemic, especially while people were staying home, they spent a whole lot of time on social media, on the internet, and there's surveys that have been done that show a large increase in the number of people researching internet sites that have IMVE content. So we have seen that trend. We have seen also the number, as is written in this summary, the number of threats targeting public officials, politicians have been increasing also quite significantly.
And can online rhetoric translate into action in the real world?
Sometimes, but I think, as Ms. Tessier mentioned earlier today, one of the things that we're very concerned about is the people who actually consume that rhetoric, that see those threats and get maybe inspired to conduct acts of violence after having consumed all of those narratives. So when someone posts a threat against a politician, it doesn't necessarily mean that the person has the intent to carry out an attack or to target the person. But it can and it has inspired others to do so.
If I can be permitted to add concrete examples, we saw that the attacker in Christchurch, Brendan Tarrant, had written the name of, amongst others, Alexandre Bissonnette on his one of his weapons, and many others who obviously influenced by that activity. More recently, we saw the Buffalo shooter do the same thing and put the name of individuals who have committed these these previous acts as well, writing that on their weapons. So you see the influence of these individuals who live stream these attacks and how other individuals go towards that type of content and then give them credit when they actually conduct the attack.
Is it difficult to predict the point at which online violent rhetoric translates into action, violence?
Absolutely, it's very difficult.
And you had mentioned, I'd heard the words dynamic and fluid and so forth. How would you describe that type of threat assessment? Is it done on a daily basis?
Yes, I believe I mentioned that earlier. We have to, and we did, continuously assess the situation, look if anybody was radicalizing because of the environment and because we knew that there were individuals trying to recruit people towards their more extreme violent movement.
Maybe if I could add one point to this is that we talked earlier about the very dynamic nature and evolving nature of the IMV environment. And because we are sitting at the same table with our law enforcement partners, we share a lot of information.
And sometimes it will be information coming from a law enforcement source that will inform CSIS that we may need to look at it from a national security, threat to security of Canada point of view. And sometimes it's information we would have collected as part of our own investigations that we would share to law enforcement that there might be a credible threat of a criminal activity, including, as we discussed earlier, threat to politicians and so on, that would be the purview of law enforcement to investigate. And so that is a very dynamic exchange between law enforcement and intelligence, CSIS specifically.
All right. I have a question for Mr. Vigneault concerning questions that were put to you earlier. So you were asked a number of questions about the interpretation of the CSIS Act. And you're aware that the Government of Canada has received legal advice generally on the Emergencies Act. Is that correct?
Yes.
And you're aware that the Government of Canada has received legal advice generally on the Emergencies Act and has claimed solicitor and client privilege over that advice, are you not?
I'm aware.
And you have not been given authority to waive any solicitor and client privilege over that advice, is that correct?
That's correct.
And when you answered questions regarding the interpretation of various statutes, you were expressing your own understanding. Is that correct?
Absolutely.
All right. I have a document to pull up.
You're pretty well out of time, so you're going to have to wrap up.
All right. I don't know if one of my friends who gave up their 5 minutes would cede me that time, but I see a nod. I feel like it's a bingo parlor.
I'll even cede him my 5 minutes.
I just think that I'm not going to get through what I want to, but I think some of this is important, I thought.
Okay, well, focus on...
Yes, I've got a document that I'm going to ask for your explanation of, Mr. Vigneault. It's ts.can.001, well, several zeros, 001, then several zeros, 1 again. So it's entitled Fabric of Society. It's a CSIS document. So it's ts.can.001 number of zeros, then 1.
In case it assists, there are 7 zeros before the 1, ts.can. Yep.
There we go. All right. Mr. Vigneault, could you explain what this represents and how CSIS utilizes this?
So, again, we've done a lot of work inside the organization to better understand the dynamic of IMV, what's happening in society, what are some social movements that potentially have an impact on our CSIS mandate. And this, if you can maybe reduce the font. If you look at this, it has the shape of a funnel, and essentially what we tried to do with this is to explain at the top of the funnel is that a lot of personal grievances linked to Islamophobia, oppression of indigenous people, the fear of conspiracy theories like QAnon, xenophobia, neo-Nazi influences. So there's a lot of things that circulate in society. And that is essentially what is unfortunately very present on social media. When I referred to earlier as awful but lawful, we see a lot of that potentially extremely violent and vile information. But again, this is protected by charter. This is acceptable in a democracy. And the further down you go through the funnel, you're getting into areas that might be potentially constitute hate speech under the criminal code. And at the narrowest part of the funnel, this is where CSIS, our analytical analysis described this is where the narrowest part of the funnel, where our 2C investigations would kick in. And so that is a conceptual analytical construct to help identify what is happening in society and where we versus the police versus other elements of the society should be concerned with. CSIS should be informed what's happening on top of the funnel where it's lawful. We are informed by that information, but we're not investigating that. That is, lawful information. Where we are, as I said, is the narrowest part of the funnel. So one other element that is, I think, critical in all of this is we've said earlier on that people can radicalize extremely quickly. Or mobilize to violence very quickly. So we've seen people, move from being consumer, as my colleague said, consumer of those narratives, to go down and very quickly to say, I need to do something about it. I will mobilize, I will engage, I will train, I will acquire weapon, and I will commit violence. And so this is our attempt to depict what is happening in society and where the CSIS mandate fits.
Last question. Was there a concern by CSIS concerning this convoy that others who have been radicalized in some form and were engaging in online rhetoric would use the convoy as a vehicle to recruit?
Indeed, I think it was. I don't think it was our assessment that CSIS and ITAC came to the same conclusion, where we are seeing, unfortunately, in the past, people exploiting those types of events for their own purposes, and other people who, again, very quickly are mobilizing to violence based on information, based on motivation to use such an event to engage in acts of violence.
Okay, thank you.
Okay, thank you. Any re-examination?
Thank you, Mr. Commissioner. Two brief points of clarification, I hope. I see my friend, Mr. McKinnon, rewrote the summary himself while delivering it to the witness, so it might be that it's had the salutary effect that we need here. I think this question is for you, Mr. Vigneault, and I'd ask that the summary of the closed session, which is WTS 079, be brought up, and if we could go to the top of page 9, maybe the bottom of page 8 and the top of page 9. Thank you. And this passage has had some discussion a fair bit already today, so I won't repeat the whole thing. But Mr. Vigneault, I think what some people have expressed some puzzlement about is just the way you phrased it. And that if I tried to say something in French, you would have to cover your ears. So I'm not faulting your English here. It's just that sometimes we see Francophones express things this way, and I want to see if I can offer you an alternative expression in English, or, if you'd prefer, just ask you to say it in French. The way you phrased the last 8 or 10 words there allows for two meanings in English that I think you intended only one of them. So it says, he advised the Prime Minister of his belief that it was indeed required to invoke the Act. Okay? And some people are wondering if it has any meaning other than an article that is reflexive to invoke the Act. So one way of rewording that might be advise the Prime Minister of his belief that the invocation of the Act was required, or it was, as Mr. McKinnon put it, necessary to invoke the Act. Do either of those sound right to you? And if they don't, please just say it in French, and you'll lose me, but the Commissioner will be right on it.
I think to be clearer than maybe the summary is, and of course it was not a verbatim record of what was said, it was a summary. I think if I pick up on top of page 9, opinion of everything he had seen to that point, he advised the Prime Minister of his belief that the situation indeed required to invoke the Act. I think that would be a fair assessment of what I wanted to say.
Okay, I'm going to tell you that leaves us with the same ambiguity. So, do you want to try it in French?
I'm not sure that I can be clearer than that. And if you want to put to me, the two interpretation, again.
I'll try it again. Would you think it sounded right if you said he advised the Prime Minister of his belief that it was indeed necessary to invoke the Act?
I think that would be in my head. It means the same thing. So necessary would be absolutely fine.
Then we're there. Thank you. And then on another point of clarification, probably this one for you, Ms. Tessier. Not everybody followed the graphic about IMVE the way the graphic designer probably hoped everyone would follow it, which is quickly and easily. And we were going to try to walk you through that when we realized you've actually got it written out in words in your institutional report. So if you could, Mr. Clerk, if you could call up DOJ IR 701 and take us to page 7, about 2/3 of the way down. And Ms. Tessier, if this is a question for you, I'll ask you to look at the verbal description of the placemat, which is there. And in particular, if you can confirm that that's an accurate description of what the placemat is trying to say, with us being especially interested in the paragraph afterwards, if an actor only demonstrates, which the words for us seem much clearer than the placemat was able to describe. So if you can confirm that those words are accurate, that'll resolve that for us.
Yes, they are accurate.
Okay. Thank you very much, Mr. Commissioner. Those are my questions.
Okay, so that ends your testimony. Thank you very much for coming and testifying at the commission. Much appreciated, and you're free to go. We're going to move on to the next. So I'm going to do a 5-minute break just to change the arrangements, maybe 10 minutes to change the arrangements and move to our next witness. So a 10-minute break.
The commission is in recess for 10 minutes. La commission est levée pour 10 minutes.